Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
I was doing commentary as a kid. Dati mihi Anglican for service of Jesus.
That's literally not true.
Scratch all that. Oh, that was terrible. I apologize.
Okay, so I fat fingered the intro there. Double tapped it. Got nine. Sorry about that. All right, welcome to the Court of Public Opinion. I am the Recovery Addict. It is so good to be back here. We are ready for a spicy afternoon, Ayden. We really are. And who is going to lead us? Who's going to lead us into the spiciness? None other but our favorite Lee. Shells has allowed Lee to win chat today, and Lee, in addition to all his regular responsibilities and duties here in chat, is now going to take care of the internet and make sure everything's working properly as we prepare to delve into the spiciness of this civil battle. Congratulations, Lee. You've won before. You know what to do. We'll go ahead and add this to your permanent record and expect you to maintain the internet as we know correct? You're capable of doing. What's funny is there are a few of you, and Lee, I think you might be one of them. There are a few of you out there who, if you did actually own the internet, I would trust to keep it running. It was a quick lunch. It was very quick, Shuri. Very quick. Lee, congratulations. Thank you very much, my friend. Appreciate you being here. Would not be the same without you. All right, we have objections. We have all sorts of fun spiciness going on. Let me see. Hang on. Super source, box source. Okay, 2. We have the door closer. Let's see if I can get everything plugged in. All right, total objections 593. We realize we're way undercounting today. I did not inhale any food because there was no food. We need to go shopping. I think actually Mrs. R.A. is currently shopping right now. But that's where we're at. Put this over here.
Alex stole it.
Just 1 second. I got to talk to my kids. Alrighty. Leftover cold pizza, says Robin. Sorry, I was distracted. I've got 2 kids. My 2 youngest want to do a lemonade stand. Right? They want to do a... let's see. There we go. They want to do a lemonade stand, but we didn't have any lemonade, so they decided to do a water stand where they poured cups of water and set it out there, and they were trying to sell them for $1 each. I don't think they sold any. That's why I said maybe there's a better way to do this, but we'll see. We'll let them delve into the world of entrepreneurship in the way they want to, with a little bit of guidance, but we'll see if we can help them out a little bit. Anyway, selling pre-poured water in cups that may or may not be clean, I don't think is the secret to financial success. Put ice in it, maybe. There's a start. No, it's all good.
For the trees.
The camera view is amazing, Lindsay. We've been admiring this door closer. These actually, they are not cheap. For those of you that have had to purchase or replace one of these when they do go bad, you'll know when they go bad because the door might just slam shut with a vengeance. Like so fast that you worry that if somebody's fingers were there, they would be no longer on their hand. It's crazy. Can we text her shopping list? Screeners, I think that would be appropriate, only she does not have a phone, so they would be
Alex
coming to
stole it
me,
as well.
and that would not be as effective. She did not even consult me prior to going shopping, so I have no idea what's on the list. Could do those flavor drops to the water. Some of those flavor drops have a bit of a kick to them. I mean, I'm not talking like alcohol. I'm talking just like caffeine. One of my grands set up his own toy sale last year. Toy sales. Oh, this is a good idea because listen to learn. Around the holiday season, our kids do tend to pick up a few new toys. Okay, I'm not sure how that works out or who makes that happen, but right around Christmas time, they all seem to get a few new toys, and their toy bin is full. My kids don't lack in toys, right? But some need to be replaced and upgraded, and we're always trying to get rid of the old toys that haven't been played with for say 11 months. And then when we do the clean out, okay, when we have the big day where we bring out the toy boxes and we're trying to divide things up into what stays and what goes, suddenly the toys that are in the go pile become the most loved, cherished possessions in the world. No, not that has so much dust on it I can't tell what it is. I love that. I've been looking for that. I've been wanting to play with it all these months. Let's see. Hang on, Dr. G's saying something.
What more do you need to see?
One second. Okay. Trying to balance Brandy and Dr. G. So we're texting back and forth to see what everyone's schedules are. All right. Let's see, I'm a bit behind, losing my mind listening to this depot. Depots are over, Tash. We're over at the depots. So those are tough to listen to. They always have been, honestly. It's the least yes, Mary Murphy, you're on the back burner. I'm not very good at doing two things at once. And if texting is one of them, everything else shuts off.
That was terrible.
Because I have to think and use both hands. And suddenly I cannot even look at something else other than the screen. Just offer the kids $10 for every toy they want to get rid of. That's how my sister got her to clean her room. $10, man. Yeah, Creed. Are you adopting kids? Because I'd like to sign up. I placed the to-go toys in a holding pattern in the garage for 6 months before they get donated. And Debbie, when you do that, do they just sort of disappear? It's like if they didn't notice they're gone, can you just move them and then you're good? Let's see. Check the burner phone.
Let me see if I can turn the lights back on.
Okay, judges trying to get the computers turned back on. He's going to type password 123. Ready? Here we go. PASSWORD 123. Enter. There it is. That's his password. Proffers are much better than depositions. Depositions are so hard to listen to, probably because they're edited out. So all the good bits that would have been like, oh, that's spicy,
everybody.
Are gone.
My understanding is we've got quite a few issues to address. Among them are the issues of the child victim hearsay. And apparently for the TV people, I just did something to your microphone, unfortunately.
TV people, please come front and center.
I'm sorry.
Audio guys headed up to fix it. Nothing's wrong.
I'm
it's
not
all
a
working.
camel.
That's the little mic that we're hearing. He just ripped it off his other mic. It just needs to be taped back on, preferably using. There it is. Around, and up. Tuck it in. Not even a clip. It's just taped on. Okay. Anyway, we're here.
We've got exhibits. I know that there's some jury instructions that are wanting to be discussed. So are there other issues that we also have to address? And did we figure out the shot clock from today?
I think we did. Did we get the?
Shot clock?
That's for Johnson.
Sorry. Do you have the breakdown from Ms. Beaty's testimony?
Clay had it. I talked to him. He said he's got the numbers and he was going to provide it for both sides.
As soon as we have it, we'll send it to you.
Sorry, I'm texting back and forth. We're trying to make an arrangement.
Scratch all that. Oh, that was
So-
terrible. I apologize.
You know, what's the way should we do it? Should we deal with the exhibits first and then child victim hearsay?
We'd like to deal with the child victim hearsay issue first.
And then Maya can
We
leave.
have Maya here in case there needs to be some testimony from her on these statements. And then
So these statements are the
we'd
statements
like
of her
to let
friend
We'll have the rest of the
acknowledging
discussion.
what Maya told him
Madam
about.
Clerk, we're on DIN 3433. Plaintiff's motion to admit child abuse hearsay statements pursuant to Florida statute section 90.802 paren 23. So let's start going through this, and let me ask some questions first so I can understand. I need to know what the statement or statements are that are hearsay that you intend on seeking its admission. And it seems like the first one would be by Dr. Brewerton. Is that correct? Were statements made by Maya to Dr. Brewerton?
Your Honor, I don't believe those are what we're targeting this at. On page 3 of our motion, we set forth 5 exhibits marked for identification, and I can read those to Your Honor if that's
Okay,
helpful.
well, yeah, I don't physically have quick access to these exhibits.
Sure.
So let's look at the first one, which is 2364.
Yes, Your Honor.
I think someone needs to turn on the screens, Your Honor.
I'm sorry?
The screens, I don't believe the screens are on.
Jump around
It
here.
says you've got a green light, but let me turn it off.
Try that again.
It says you've got a green light, but let me turn it off and turn it back on.
Judge doing everything he knows how to do when it comes to tech right here. Maya may have to testify briefly today. This is outside the presence of the jury. It would be
Sure.
like a proffer.
While they're working on that, I have the time. Do you want the shot clock
What's
done?
and is it agreed to?
Scratch all that. I believe so.
Okay.
Yeah. For the first video, it was 37 minutes of defense and 32 minutes for the plaintiff.
So the law here, the Greener's quoting here says,
For the second video, for Miss Betty, it was 46 minutes for the plaintiff and 45 minutes for the defense.
Okay,
court
so
statement
what we'll
made by
do
child
is
victim.
plaintiffs will be 30 and the defendants will be 40,
is admissible.
and then 45
This is why we're
and
hearing it.
45, which means plaintiffs have an hour and 15 minutes.
Maya's only going to be here for this portion of the day. I imagine she'll leave as soon as this is over.
That's what, 40 and 45. So it's an hour and 25 minutes. So
I held this up
that
thinking I could
means,
open this
plaintiff's
jar
cumulative
on camera.
total is 25 hours, 40 minutes. The defense cumulative
I'm gonna
total
get it.
is 9 hours, 35 minutes. Any questions on that, or are you ready to go?
No questions, Your Honor.
Your Honor, I'm flipping back to our original way, so if you want to turn on my table, I can get us back because Mr. Cottrell must have configured it a certain way, and I'm not going to spend too much time with that.
I've already switched it over.
Thank you, sir.
There you go. But wasn't that a problem for the other TV folks of running it through your feed?
Well, until I can get communication from him, I'm gonna just do this now so we don't waste the court's time.
So he's just arbitrarily cutting us out of the picture.
Okay, so you're showing me 2364. Okay, how many pages is this?
Your Honor, this exhibit is 21 pages. This is my special care journal provided to Maya Kowalski during the time that she was sheltered at Johns Hopkins Hospital. And it is her present recollections at the time, many of which describe the abuse and neglect that she was suffering at the time. I direct the court's attention, if we could, to 2364-010. I direct the court's attention to number 4, blood pressures, number 5, not getting my pain managed well, number 8, not getting to see my family, number 11, having visitors getting kicked out.
Well, let me just stop you here, because normally when we talk about child victim hearsay, it's a statement by, let's say, a therapist that would say, the child said X. This is actually the statements of the child directly. So I'm not sure the child victim hearsay analysis applies for Maya's own journal, assuming that that's what this is.
If they tried to bring this in on another witness, it would be hearsay.
Am I missing something on this? I mean, there might be hearsay exceptions that apply for it, but I'm not sure this is a child victim hearsay question.
Well, if we're on this one, it looks to me, again, to be an 8033, as much of our stuff is then existing mental, emotional, physical condition, documenting how she's feeling, what she's feeling, why she's feeling it. And these are being documented at the time. They are confirmable by the testimony of Maya Kowalski, indicating that's an indicia of trustworthiness. They are relevant and material, obviously, to what she knew was happening to her at the time. It was according to a defense request for her to record that, apparently, although it didn't come out quite like they wanted. This was supposed to be her journal of what a great time she had, although it had things I did not like while I was in the hospital. So there's, I guess, both sides
to it.
Defense request. As all what evidence does, it cuts both ways.
Well, who gave this to Maya? Let's just start there.
The hospital did at the start of it.
And did she, and I know if I need to get testimony, I can, but did she fill this out while she was in the hospital?
Yes, sir.
And at that time, when did you fill it out? During your stay?
Well, before if we're going to have her, I'm going to need to have her under oath and all that good stuff. I'm just trying to understand what framework I need to be looking at this at. That's the purpose of my questions, not for a factual basis.
Unless I need to be corrected on this, but this was given to her at the start of her stay, and it was not directly a chronology, but there are different pages that, as she stayed in the hospital, she filled out about the events, but mostly, from her point of view as a 10-year-old, how she was feeling about things and what her physical condition was, and the emotional state she's in. So if the court looks through them, I think you'll see that although there are some, like it says, some food she doesn't like, but most of them are about her physical condition, what she likes and doesn't like, and her emotional state.
I'm looking back at the statute. Actually, I don't see anything in the statute that would restrict it to only statements made to others. The statute seems to be a little bit more broad than that.
That was our conclusion.
It's generally you see it with a statement made to like on a CPT video or some type of statement to a therapist or a parent or something like that. And okay.
Although we can bring it out, I am fairly certain that this was intended by Maya to document what was going on at the time with the hope that her mom or dad would eventually see it. And I can elicit testimony to that effect.
So perhaps it does seem like now that I'm looking at the statute that this could qualify under child victim hearsay, might also qualify under other exceptions as well. So who's from this side of the room going to be talking about?
First of all, I think I agree with you that or your initial take on 23 is that statute is designed for statements that are made by a child, typically to a police officer or to a therapist or to a neighbor or a family member, and you're calling upon that person to put it in. The reason you're doing that, the reason this was created, was because you have a small child who either may have forgotten or may have been intimidated, or there was some reason why the child, while available to testify, that the quality of the testimony was going to be impinged. And so you put on the hearsay because it's actually maybe more reliable than what the child will take from the stand. That's normally in a criminal case. The only civil cases I've ever seen this used before, by the way, are DCF proceedings and Jimmy Rice proceedings. I don't think I've ever seen this in a true civil case. And I have never, ever in any of these things seen it when someone is 17 and a half years old and more than willing to get on the stand and provide competent testimony now about these things in the past. So I don't think this fits into Chapter 23 very well. And then if we get into state of mind, we can go, through the details of this. But that's supposed to be a statement about a then existing state of mind, an emotion, or a physical sensation, including an intent, a plan, a motive, or design, a mental feeling, pain, or bodily health. And it's got to be something that is relevant to an issue in the case, or to be something that explains subsequent conduct, not by any other person other than by Ms. Kowalski. And I look at these things, and they really don't seem to fit into that particularly well at all. These are just very generalized statements. She didn't like blood pressure. Okay, she didn't like blood pressure.
Well, let me just look at one more thing and then come back.
They're whining. It sounds like this is coming in from what the judge said earlier, but now he's rethinking it. If he does rule that it's not going in, I'm sure that plaintiff has another angle that they'll want to address on this one before they give up on this fight.
I mean, I agree with you, Mr. Altenburn, that you normally see it, like I said, in some type of someone else testifying as to what the child said. Now, I have dealt with child victim hearsay in civil cases before, and I think my last order in that was like 14 single-space pages dealing with it. And I also have dealt with it on the family law bench several times, and of course, when I was on the felony bench, way too many times. But I've never seen it used for the declarants like a journal. And the statute says circumstances by which the statement is reported indicates a lack of trustworthiness. So I guess the question is, does that mean it has to be to someone else, or is a statement made that by the declarant, the child declarant, into a journal? And I would, and just looking at that, I would seem to think that the statute's broad enough to allow it to also include statements in a journal. So for my purposes, I think we can view this under a Section 23 analysis if we need to, but.
And the only thing I'd point out is that once you go through Section 23, then you got to go back to the rest of the hearsay to make sure it's admissible under another hearsay rule. That just allows it to be considered, but it doesn't need to establish that it's not hearsay for another reason. So if, and Mr. Anderson's pointing out that he thinks it's state of mind is how it fits. And so.
Well, and clearly at this point, it's Maya Kowalski's state of mind that we're talking
Correct.
about would fit under.
It was her, Maya Kowalski's then existing state of mind and whether it's relevant to some issue in this case.
So as it relates to this particular document, before we walk down the Section 23 child victim hearsay.
Or we'll look at 3 state of mind
I mean,
first.
why is this just not admissible under the state of mind hearsay exception?
Particularly since Kathy Beatty just put the issue of how she was doing at the hospital.
On an unknown date while she's in the hospital.
Well, we have narrowed the date.
Okay.
It was given to her apparently on video. Our paralegal tells us during the 48-hour recording is when she was delivered this journal.
Okay.
Boom.
Things I did not like while I was in the hospital, not seeing family. Okay, that's a statement of fact, that she did not like seeing the family. Does that explain her existing state of mind on the day that she wrote this? Does it show her emotion or a physical sensation on that day? Is it a statement of an intent, a plan, a motive, a design, mental feeling or pain or bodily health? She's just saying that she didn't enjoy the fact that she didn't get to see her family in the hospital. That if that fits that description, practically any opinion about likes and dislikes becomes admissible as a state of mind exception. And that's clearly not what this statute is designed to allow into evidence.
If you're being neglected at the time as a 10-year-old.
Maya just left.
I was just going to make that point. I mean, we're talking about a 10-year-old child who is asked what she didn't like. And isn't this the means by which she is expressing those? I mean.
Yes.
Yeah.
I mean, that she
I haven't
didn't
seen
like
the other
that.
pages, but is there anything in the other pages that are problematic from any side's perspective?
I haven't gone through every single one of these pages.
We can cycle through them. Some of them are pretty innocuous, and perhaps the hospital wants to use them. So
She doesn't like some foods.
And she also likes some things. So
Yeah.
we're willing to put the whole thing in.
I just, she can get on the stand and explain all of these things. It's not like she's 8 years old and forgot it all.
I mean, clearly she could use it to refresh her recollection without any problems.
Correct.
Can we just cycle through the pages and see? Let me see what's in there.
Would you like to start at page
Just
1?
start at the beginning.
To the parent or guardian from the
So the
chaplain.
point was to express her thoughts and feelings. Okay. The next page, please.
You can tell me anything that's in your heart. You can draw pictures and color them. Whatever you write is always just between us.
Next, please.
Important stuff. My nurse is Amanda. Hospital's all children's. Today's date. It's got the date on there.
Okay.
Miss my family. I want to go home with my family and friends. See my family. Call my friends and family. See my friends and sleep in my own bed. That was the I wish I may, I wish I might. Drew pictures of her with her in the wheelchair. Here's a picture of what I wish for.
You remind me who Corrine is?
Her older stepsister.
Oh, that's right.
Half-sister.
Next page.
People I really liked at the hospital: Kaylee, Megan, Barb, Amanda, Victoria, Michelle, and Lindsay. Amanda at least was a nurse or doctor. Debbie, Alicia, Sylvia, Angela, Nicole.
We saw that one. The next page.
Good nurses, doctors will People visiting me, RJ's Activity Center, things she likes, arts and crafts, movies, some rooms had good views. Once Daddy came and visited me, I miss you all. Some foods, RJ's Activity Center, going on strolls. Good nurses, sitters, and albuterol doctors when I have them. I can write my thoughts in the clouds. I miss my family so much. I want to see my family and friends. I'm hurting. I want to go home. I want to be at home, lay in my own bed, and have fun with my family. I miss my family and friends. I don't want to go home. I want to go home and have family. I have my friends and family visit me, sleep in my own bed, see my subdivision and neighbors. I hope God will hear my prayers, not having to do vitals. Here is something I love very much, my family.
Can you turn it?
My favorite things to do are read, love school, play with my favorite toys, being with my family, being with my friends, being with my awesome neighbors, paint my nails. Maya is back. Not being able to see my family or friends, things she doesn't like, not being able to call anyone without supervision by nurses, or just not being able to call them when I want to, not having family and friends with me, and not being at home.
Next one.
My family, my friends, things make me happy. My neighbors, my home, my arts and crafts, Shopkins, Tum-Tums, mystery minis, pop-up something, a picture to color that she did not color. Nothing on that one. Manatee, dolphin, dog. She's just drawing pictures of her Shopkins or animals, I think. Family, friends, these are important to me. Family, friends, neighbors, neighborhood, my house, church, life, Jessica or Jesse, my bear, Jesse, manatees, monkeys, dogs. Here's who I look like. That's me. That's a picture of her. She drew herself with a necklace. That might be interesting. And just like that, we've got a feed that dropped. See if we can swap this out.
Objecting to the entry of this document.
As to the hearsay, yes, Your Honor.
It would need to come in with a limiting charge that's being limited for purposes of not the truth of the contents, but for the child's state of mind at the time it was prepared.
No.
Mine is gone again.
Clear in the standard jury instruction. And the more special instructions you give this jury, the more chance of inconsistency and confusion.
The following document is being introduced to prove the state of mind of Maya Kowalski at the time of her stay in the hospital in October, whatever these dates are. It is not being introduced to prove the truth of the factual statements or the accuracy of the opinions contained in the document.
Well, then we're going to have to do
time out.
Sure.
It would seem to me that you can use child victim hearsay substantively without limitation if it comes in. So in my mind, it certainly falls under sub 3 for then existing mental, emotional, or physical condition. And I think it also could qualify, although technically we'd have to have the hearing that was necessary to admit it. But if it comes in under sub 23, I don't see why I would have to give any type of limiting instruction. I mean, does Professor Padovano say otherwise?
If it goes through both hoops and it gets to 23, that's substantive evidence that she doesn't like food.
So
it's substantive evidence of the statements of fact in it. That's what it is.
So if we would probably need to do the hearing as to that one, because that sounds like they want to use it for substantive evidence.
Keep in mind, it needs to be a statement of the child victim describing an act of child abuse or neglect. So you have to find that these things are child abuse or neglect because they're not criminal offenses. I think giving her bad food is not child abuse or neglect. It's hospital food.
Well, it's not limited to just that.
I know. I
think that is Maya in the hallway there, talking to somebody out there.
And it has to be read in context.
With her brother, I think.
So it sounds like we'll have to have a hearing on that one for whether it would qualify or not. Okay, what's 2365, Exhibit 2365, what's that?
This is a statement taken down. These are statements of Maya Kowalski taken down by her father, Jack Kowalski, at the time in which she's informing him of different instances of abuse and neglect.
So this would possibly qualify under that same.
I'm sorry, say that one more time.
All right, this is a writing of Mr. Kowalski. So he is recording what Maya Kowalski has relayed to him during one of his limited visits regarding the abuse and neglect by the hospital, and in particular, Kathy Beatty, in the hours and days leading up to his visit.
Okay, so this is more of the classic child victim hearsay type statements. Is there any other basis, hearsay exception that the plaintiffs allege this falls under?
Well, it is again, and many of ours are a 8033.
It would also be 8034. Some of these would fall underneath statements made for medical treatment or diagnosis, keeping in mind that she's a 10-year-old child and she's relaying for example, that she's not getting any medication. So she's trying to seek medical treatment.
To her parent or guardian to relate. So this is the way she can relate at 10. To relate the medical information through her guardian to the doctor.
This is a document explaining by her father that she has brought up. She brings up these issues without me extracting this from her. He's not purporting that these are actual statements made by her. And then the very first one is hearsay upon hearsay. Kathy informed Maya that her mother, Beata, is getting mental treatment.
Yeah, qualifies as admission.
Well, clearly, the child victim hearsay would be what Mr. Kowalski testified that Maya Kowalski said.
Correct.
But this does look like it.
That doesn't
would
put
need
the
a hearing
document
on it.
in as compared to his testimony.
Yes.
Can you redact his phone number real quick? He might get a number of text messages.
Okay.
We're going to cut from that screen just for a minute while they redact the audio. Or redact
That
the
doesn't put the
hearing on
document in as compared
There
to
we go.
his
The
testimony.
next one is akin to the first, which would be writings by Maya Kowalski while in the hospital,
Okay.
describing
What is-
events of abuse or neglect. Well, excuse me. 2365 had several pages, Your Honor. So there's 4 relevant pages, 2365. So we should probably show you the rest of that one.
Okay, let me see the rest. And it might be, okay. I think to be accurate, it's not that this document 2365 would come in. It would be Jack Kowalski's statements as to what Maya Kowalski said. He could use this to refresh his thoughts, but it's Jack Kowalski's statements as to what Maya said. That would qualify under Section 23.
Not the document.
Not the
itself.
document.
Okay, if the court is saying that if she had made the statements to a therapist or detective, that the written report of that therapist or the progress notes of that therapist would not come in?
What normally happens is the therapist comes up and testifies, the child victim said X, Y, Z.
Understood. So that would only apply to page 1 of that exhibit because those are Jack's present recollections. However, 2, 3, and 4 are, again, we're back to Maya's writings.
I think this is the one we talked about the other day, referring to this was done at the request of an attorney.
It was done
It
for
does say attorney at the top, but there's no evidence that we're aware of that the attorney requested this. This is
Well, I think I'm going to need testimony as to the balance of these pages. I'm not saying it is or isn't child victim hearsay. I'm just saying I'm going to need testimony on that. Okay, what's the next one? 2366.
And 23661 looks to be,
Same document.
yeah, it looks to be redundant.
So that's the same as 2365?
It's 23366 is one of the pages that is part of 2365, so I think we could ignore 2366 and 23.
That is Maya's writing, yes.
7.
When she was
they
10.
Are both part of 2365.
Sharaz, thanks for gifting 5 memberships. I think right before that, I think Krista gifted a membership as well.
Please 2380.
Sassy Southern Law Nerd, congratulations. Michelle Marcus, Amy Marie, Lori Smith, Gypsy Moon,
2380, please.
So
and from
2380
Krista, Kale Smith, who gifted
is
memberships.
Effectively, Jack Kowalski's notes, both handwritten and then his process was to, when he returned home, to type up some of these notes. And it's, again, back to statements made to him, and he's recording what Maya has relayed regarding the abuse.
Well, show me, because the first one looks like a discussion with somebody from the DCF. So show me where he's talking about statements that Maya made.
For example, in the second paragraph, October 27, 2016, she requested communion. So that'd
Mr. Reyes, can you highlight whatever Mr. Whitney's talking about?
The last sentence says she requested communion. That'd be a statement of Maya Kowalski.
Well, that one I think is going to have more difficulty falling under child victim hearsay because Mr. Altenburn's right. There still has to be, for child victim hearsay, it still has to be grounded in some type of wrong that is more criminal in nature.
Understood. Let's turn to 2380, page 8. And this is the last part there, Friday, January 6, 2017. It describes the improper photography session by Catherine Beatty as relayed from Maya to Jack.
That's coming in.
Again, this one would, if it met the reliability test, the content of the conversation between Maya or Maya's statements to Dad potentially could fall under child victim hearsay, and especially since this one actually involves a battery, an alleged battery. I think this one could be, so we would need testimony under child victim hearsay. Mr. Altenburn, any contrary thoughts?
And my only confusion too is that it's dated Friday, January 6th, but the last part is upon her return to All Children's Hospital, Catherine instructed her to remove her clothing and take photos again, which she could not have told him that on January 6th. I don't know.
She absolutely could have. She went to court.
These are things you can bring out on cross-examination. I still have to find trustworthiness and all those other things. It's just, I think this one is something that we could have here. So it seems like we're going to need a hearing on number 1, number 2, and number 5.
I'm sorry, when you say number 1, you're talking about 23.
On page 3 of the motion.
I'm sorry, I don't have the motion for me.
Yeah, it looks like trial exhibit 2364, 2365, and then 2380. Now, as it relates to those last two, it's not to put in the actual exhibit. It would be to allow Jack Kowalski to testify as to what Maya said.
Understood.
Okay. Now, and thinking about number 1 more, it does. I'm more confident now, just kind of thinking about it a little bit more, that there can be some sort of journal entry that would qualify as a child victim hearsay, so long as you can show the other components of the statute. So, do we want to go ahead and have your witnesses? Is Jack Kowalski here?
I'm deciding him.
You were blocking him. Okay. So, let's go ahead and have the child victim hearsay hearing.
Here's the hearing right now. So this is a proffer. They're going to do this hearing.
Whatever you want or need.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Your Honor,
This
just
is
to
Miss
save
Lisa.
time on the
Thank you.
journal, so long as the whole thing goes in, to save time, we'll just agree to let the whole thing, we don't want segments.
Well, I think that's what Mr. Whitney said is they were fine with putting the whole thing in. So at this
That's
point, are we,
stipulated
Mr. Whitney, I think this is what Mr. Altenburn, I think, is saying is they're okay with the entirety of 2364 coming in, which is number 1 on your list.
Great.
Okay, so the court will receive 2364. That's a completed issue, and now we don't need to worry about that.
I don't think the family will settle at this point. I think they've got the jury in their pocket, and there's no reason for them to lessen what they're asking for.
Jack Kowalski.
May I approach with 2365-001, Your Honor?
Sure.
Sorry.
Can we publish it?
Just put it out on the screen. Oh,
Want me to turn it? I could get
yes, and actually put it back down on the ground. Sure. But let's not make it on the cord.
Okay. Does it go on?
Well,
Oh,
yeah,
right
there you go.
Awesome.
Well, you still have another cord under it.
Okay.
Thank you.
I believe it's so that the feed, the video TV feed is going to be able to pick up the exhibit.
I just switched it, so you tell me if it's fixed.
I will let you know.
Sharon, you were gifted a membership by Annie Marie.
I'm breaking technology left and right, aren't I?
You're doing great. You can put it back later.
I told you I'm not a TV director. Mr. Anderson, you may proceed, and Mr. Whitney wanted the Exhibit 2365. What page, number 1 was it, Mr. Whitney, that you wanted that?
1, Your Honor.
Yes, Your Honor. 2365-1.
May I please, Clerk?
Yes.
Please state your name for the record.
Jack Kowalski.
Where do you live?
I live in Venice, Florida.
Are you the father of Maya Kowalski?
Yes, I am.
During the time of her stay at Johns Hopkins Children's Hospital between October 7th, 2016 and January, I think, 13th or 14th of 2017, did you visit your daughter frequently?
Yes, I did.
And during those discussions, did your daughter relate to you certain unsettling or troublesome issues regarding the way she was being taken care of?
Yes, she did.
And did you then, at or near the time, record these in a note for future reference and memory, and to point out the different abuse and threatened abuse against your daughter?
Yes, I did. I documented every time I went for a visit.
And is this trial exhibit 2365-001, was this completed at or near the time of a visit?
Yes.
Do you recall approximately when?
I usually jotted it down on a piece of paper, and then I would type it when I got home.
So this is the typed referral of it?
That's correct.
And in this, did your daughter state, among other things, that she was scared to talk to the judge in court because she was worried about...
Mr. Anderson, I'm going to want him to testify as to what she said. I don't want leading as to what she said. I think
Right.
I cannot have leading on this one.
I understand. What did she tell you at the time that you recorded this?
Well, anytime she felt there was a problem, she would tell me or write it down on a piece of paper.
And was she coerced in any way, or was this voluntary?
No, that was all voluntary.
And this is offered? Was this offered? What was the word I was looking for? Sorry. Was this volunteered?
She initiated it and gave it to me. She wanted me to know.
And can you relate what she related to you as best you recorded it, using this to tell us?
Yes.
In terms of, and I know there's a lot there, but in terms of abuse neglect?
How she would tell me, or I'm
Just
sorry,
what she would tell you.
she would tell me, if there was a problem, how she's being treated, things like that, and then also she would write it down on a piece of paper and give it to me also.
What were the types of abuse that she told you about on the visit that resulted in this recording?
Okay, I could read a couple here just to give you an idea.
Sure.
Well, I need you to tell me what she told you.
Tell us verbally what she told you that prompted you to go home.
She was stating that she was having issues within the hospital that she didn't agree with, that she felt that they're not doing appropriate things.
And can you describe more the inappropriate things that she was doing that caused you concern that your daughter was being abused or neglected?
Yes, there was incidents where the social worker was hugging her, kissing her, making faces while mom was on the phone with Maya, the supervised phone calls. She would make expressions, things like that. The social worker, she told Maya that mom's in the hospital getting mental treatment. There was a doctor, I believe it was Elliot, stated that mom was put Maya in comas every week at home. And it went just on and on. I mean,
what, if anything, did Maya tell you about her need for medication and what doctors informed her concerning that need for medication?
I can't have leading at this point.
What, if anything, did Maya relate about her need for medication?
Well, there was an incident that I could remember. The doctor said it was all in Maya's head, that she didn't need medication. It's hard to remember all these.
And what, if anything, did Maya tell you about her need?
She was in pain.
About her need for medication.
She was in pain. She needed medication.
Move to admit.
Brief cross-examination.
Brief cross.
Yes, and then I'll probably have questions, so go ahead.
Well, if Your Honor has questions first, you're welcome to. I didn't mean to cut Your Honor off.
No, I'll wait till after you're done, because if you cover what I'm going to ask, then it's better for you to do it.
Good afternoon, Mr. Kowalski.
Good afternoon.
That you had testified a moment ago about having a visit. What date was that visit, sir?
I would have to look at the document. I don't know the exact date now.
Okay. The description you had of Maya telling you that someone was hugging or kissing her, do you remember what date that was?
I have a journal that I wrote in, and that was all my notes were turned in to my attorney, and I believe you have a copy as well. And that does have the dates of all those incidents.
The discussion of people making faces at Maya, do you know at what point in the hospitalization that was?
It's within my notes. I do not know the date top of my head.
The discussion of the doctor disputing whether Maya has pain, do you know what doctor that was?
No, I do not on that.
And what's marked here for the court as PLT 034197, would it be true that you do not have an approximation as to when you generated those notes?
Not at this time, I do not, no. But like I said, you could find all the dates within that journal that I made up. You will find all the dates.
I appreciate your time, sir. Thank you.
Did you bring that journal with you, by any chance?
I do have mine, yes.
May we approach?
It's in my bag.
Refresh his recollection.
If it refreshes his recollection, that's fine. Now, before you show it to him, you got to show the defense.
Defense gets it too.
This has been previously produced on numerous occasions and used
Let's
as legal
just show it to the
deposition.
They're going to look and see if there's anything new in this journal.
No, these are
Some are his, some are not his. I'm going to have him turn to those that are either typed or in his handwriting.
Respectfully, I still haven't seen a note that you claim. There's a book of several hundred pages. Most of those are not his writing.
He has testified previously that he took handwritten notes.
I have to interject because
It's
leading on this issue.
What we're talking about at this moment is refreshing the recollection. And that's all we're talking about. And pretty much he can look at anything if it's going to help him refresh his recollection. Now, certainly you can look at whatever's being shown to him. And then you'll be able to ask him questions about it. But perhaps if that's his journal or something he has compiled, perhaps it's best for him to figure out where in there we're talking about.
Right. I'm very well aware of the broadness of refreshing witness recollection. What was handed to me looks like about a 400-page notebook, of which in skimming it, none of it is his writing.
Well, here's his writing, so that's inaccurate.
Well,
that's why we said we were going to have him identify it.
All we're trying to do is right now figure out the date. Mr. Kowalski says it's in his journal. So let's show him his journal and let Mr. Kowalski figure out what we're talking about as far as the dates.
I'm hoping.
And we can show everybody the specific page or pages.
And you're representing the court that that's his handwriting?
I am about to, if I can ask the witness. May I approach, Your Honor?
Yes, but let him figure out. All we're doing is giving it to him. You don't need to ask any questions. Let him figure it out.
Thank you.
I'm worried that there's new stuff.
That's my handwriting.
The issue is, you said that you needed your journal to
Yes, sir.
remind yourself of the dates, so
Okay.
let's figure that out first.
It's going to take a while, just so you know. Sorry.
Okay, so I was concerned when he said I still have it with me. He has a journal, an ongoing journal he's keeping.
I have a suggestion. Since the other two will likely require the same thing, may we have the witness go through them and we can then move on to 2 or 3 other matters in the interest of time, or you want me to wait?
I want to address this issue first.
Yes, sir.
Jack's flipping through a 400-page journal. I was concerned that he had new entries on there that had not been provided over to defense. And, you know, if there's notes about their trial strategy or something like that, that now the defense has legal right to read. I hope that the plaintiff has done their homework here and knows what they're doing.
No.
Because any notes he uses to refresh his recollection, they have access to. They have his journal, bring their copy of his journal and look from there. That would be smarter.
Mr. Kowalski, given the statements made within there.
Time out. No questions. Let him figure out the issue of the date.
Okay. Let's see. That's not it. I didn't really look at this list. Do you want me to compare it to the, or just come up with some of them? I mean,
You said that you needed to look at this journal to remind you of the dates that Maya told you the statements that
sure.
that you just told
Okay,
us about.
I got some handwritten notes from her. I'll go to that. I'm sorry.
That might complicate the issue. I've got some handwritten notes from her. This is a book without an index, so he's flipping pages looking for a familiar page. It's like a scrapbook.
Mr. Reyes can tell you the issue that's going on.
Tech just showed up. Yes.
A lot of pages.
His face isn't as flustered if we look at the at some of the other feeds. Like this. Still somewhat flushed, but
it's in here.
Just backed up a little bit. So.
It's in here.
So court IT to the rescue. Thank you.
Okay, I found her notes. There's no dates on them, so I'm sorry. I'm going to go back and keep looking and see when those were from.
He has copies of her notes, copies of his notes, typed versions of his notes, all sort of assembled in one big journal.
I don't know exactly what's on here, but okay, here on let me get the date. Here, Friday, December 2nd, 2016, PLT 035171.
Friday, December what?
I believe it was December 2nd, Your Honor. Let me check. Yes, 2016.
Whatever page you have that refreshes your recollection, why don't you just show Mr. Shapiro and Mr. Anderson that specific.
This is one of them. I'm sure there's more.
Come on down, Mr. Shapiro.
Thank you, sir.
Come on down. That is a nice tie. Mr. Anderson has a sweet tie. Somebody commented on it this morning. Eric, I'm not sure if they'll get the whole journal.
You want me to keep looking for more? Or?
I think for now, no. Let's just keep going. Mr. Anderson.
Have you had your memory refreshed as to a day? Strike it. Did Maya
scratch all that?
Keep reminding you through the course of your?
Yeah, you can't have meeting.
How often would Maya remind you once an incident happened?
Same leading order.
How often?
That one.
She would state several times on certain, occurrences or episodes in reference to her phone and things like that.
And so, have you determined a date when the majority, if not all, of these in the submitted exhibit were related to you?
I don't, I'm sure it was various dates, but I do not recall the date on this piece of paper here.
What, if anything, happened on Friday the 2nd in 2016?
There was incidents on that.
And did you record that at the time?
No, not on those.
How do you know that there were any of these taken down, these notes taken down as of Friday the 2nd of 2016, the date you had previously given us?
This was in my journal. I just documented. I had a problem from the first visit. We drove up there and we were denied, and that was an hour to travel up there. We were denied, and I didn't want to cause problems, so I just kind of bit my tongue and went home. And I figured by documenting, that's how I started documenting everything.
All right, so in terms of what's written on the exhibit and your handwritten notes, can you identify for the court whether those notes were transcribed, doesn't mean to be all, but those notes were transcribed on Friday the 2nd, 2016?
Yes, yes, that is correct. Whatever date it was documented, that's the date it happened, yes.
And it was your routine practice to
Object to the leading.
Ding, ding, ding.
What was your practice regarding these notes to make them clearer and more legible?
There's times I wrote it on a little piece of paper. As you could probably see on the first page, that's when it first started. They were just tiny little, could I hold it up or no?
If you want to.
Okay, just tiny little pieces of paper. So and by just scribbling on there, it's hard to read, and probably later on I wouldn't be able to read it. So I would type it out and then date it.
And did this become your practice as time went on with these notes?
All the time, yes.
And did it become a routine for you?
Each and every visit.
Questions, Your Honor?
Mr. Shapiro probably has questions.
If I understand your testimony, sir, the document that we've been provided seems like a compendium of different things that you've retyped from various aspects of your notes over time. True?
True.
Okay. And just to be clear, the exact date of the exhibit 2365001, when that was prepared, in fairness, you don't know the date that was prepared. True?
That most likely is true, yes.
Okay. That's all. Thank you.
Okay, thank you.
Now, let me ask you a series of questions. So, what I wrote down as far as the statements that you are relaying to us that Maya told you, and this is in regards to 2365 and 2365 only, was one, that a social worker hugged and kissed Maya and made faces when Maya was on the phone. The second statement would be that the social worker told Maya that Maya's mom is in the hospital getting mental treatment. The third statement that Maya told you is that Dr. Elliott told Maya that her mom was putting Maya in a coma each week. And then the fourth one, and my notes are a little unclear, so correct me if I'm wrong, is that I think you said Dr. Elliott said something to Maya that all of these items are in Maya's head.
I believe it was Dr. Elliott. I could be wrong on that. I could go through my notes and find it. But yes, I made these notes after her talk.
And the December 2nd date of 2016, is that the date when Maya told you these four statements, or were these four statements told to you at other times?
Those would be the day that I was notified.
Well, you're saying passive voice. When did Maya tell you?
On that date of visit.
And tell me about that date of visit. What was going on? Who was present? Paint me a picture, if you will.
Maya liked going out of the room as much as possible because she was in there all day, confined to that. A lot of times we would go down to the lobby, she would play piano, go to the rec center when she was physically able or, had the strength. Sometimes just going in the hallway or just going to get some food down in the cafeteria, she would bring things up.
And was there any supervision of your visits on this December 2nd date?
I honestly couldn't tell you from the top of my head.
Do you have any recollection as to, besides you and Maya, if anyone else, when I say was there, was within earshot of your discussions with Maya?
No.
No, there wasn't, or no, you don't remember?
No, there wasn't. I believe there wasn't.
Maya was 10 at this time?
I believe
or
so.
Or just about ready to turn 11?
December 10th is her birthday, so.
So she was almost 11?
Yes, sir. And, Your Honor, all these notes were produced to Deborah Salisbury when that all took place.
That's fine. Right now I'm just trying to get at what you remember. Okay.
The judge is going through the legal
Is there anything else?
check boxes to see if we can allow these.
Additional information from this witness about this issue, and then we're going to move on to the next one, which is 2380.
I think it would help. I knew what the which issue the court would like me to pursue.
Well, right now we're talking about the statements that Maya allegedly made to Jack Kowalski that are encapsulated in your Exhibit 2365.
What, if anything, did Maya tell you about Kathy Beatty?
Number one, she did not like her.
What else? Tell us everything you can remember that Maya told you on this date about how Kathy Beatty treated her.
Well, like I said, there's times she made smirks in front of Maya during the phone conversation. She stated that she placed her on her lap. I never gave consent, by the way, on that. She stated that she used to come in, slap her leg to see if she was in pain. She said that she wanted to adopt her, that her mother was in a mental home, so she could be like her mother while she's in the hospital. There was a time that Maya was on her school computer. She said, "You're probably searching sex websites." She's a 10-year-old girl. I don't think they would know how to go on there. I know Maya was upset about the dress, missing, and that ended up being Kathy's office.
What, if anything, did Maya tell you about?
Oh, I'm sorry. Well, then we had the pictures. Maya told me that if she didn't get the pictures, she was unable to go to court, according to Kathy Beatty.
What else did Maya tell you that Beatty said about going to court?
She was scared. If she challenged Kathy, she was scared that she would not be able to go to court.
What, if anything, did Maya tell you about the hospital and what she did not like about it in this conversation, as you recall?
Well, number one, she didn't get her treatment. She was distant from her family, and it was difficult to communicate with her family, including going through her lawyer. It sounded like there was, she was scared. And she wasn't getting the proper treatment, so.
May I approach?
Yes.
Stop.
Approaching the back.
It's a minefield here.
No,
I
just
approached
grab
you.
it.
This one. I didn't really read it.
Hey guys, all different sorts of opinions are welcome here as long as they're shared respectfully. The mods will keep an eye on it. You don't need to chat about anything. You don't.
What
we
if
don't want
anything did
conversation
Maya
about
tell you
certain
about
people in chat.
attempts to stand her up out of the wheelchair?
What did Maya say to Kathy?
No,
Or
this is in general.
Well, number one, she couldn't stand up. There was a time, one of those third
I'm
party.
sorry, Mr. Anderson. I need the statements that you are trying to admit under
Right.
child victim hearsay that Maya made to Jack Kowalski. That's what I need to focus on.
I understand. What, if anything, would the nurse do when the phone rang insofar as observation of Maya?
Number one, the phone was moved far away from her bed. It would ring.
Mr. Anderson, maybe we're not communicating. This is statements that Maya made to Mr. Kowalski. I need to know the specific statements that Maya said to Mr. Kowalski and the circumstances surrounding those statements.
What did Maya tell you? And what was the context regarding the way the nurses responded to the phone ring?
I object to the leading again.
Sustained on the leading.
What, if anything, happened on this date insofar as Maya relating to you an incident with... What did Maya say about the phone?
It's still, I apologize, it's still leading, Your Honor.
I agree.
What?
Yes, that was a leading.
What else did Maya tell you that day?
There was a time she reported the phone did not work. I did take that to the attention to one of the nurses, and like after a day, I believe it was fixed. But a lot of times the phone was far away from the bed.
I think that's all that covers it, Your Honor.
Since you're up, and so we...
This is painful.
Is there anything else that you want to address with respect to Trial Exhibit 2380, which is number 5 on the motion?
Mr. Anderson is fumbling this one. Jack, I'm going to give him some space and some leeway here because he's not the professional, but Mr. Anderson needs to know how to elicit this testimony from this witness. Why is he not prepped? Jack doesn't understand what he's asking.
One final series of questions. Where were you when these statements were made by your daughter to you?
Within the hospital, like I said, it could have been in a room, it could have been down in a rec center or a cafeteria, things like that.
Your Honor, were you referencing, should I then ask about the other exhibits as well? Or?
Yes, let's just finish it out so that we can try to bring some resolution to this.
May I approach, Your Honor?
You may.
Or actually, we can put this is Trial Exhibit 2380-008. Now, what date were these notes made?
Here, I see Friday, January 6th, 2017.
Look above it, and from what Maya told you, is it true for that part of the memo as well?
No, that would probably be another date up above.
Can you tell us approximately? Can you tell us what date?
Could I look here real quick?
Absolutely.
Probably. Okay. Friday, January 6th.
Okay, Mr. Anderson needs to ask questions that are not leading, that are admissible in court, that will guide the witness to recount the experience, to basically say, I visited with Maya. She told me, or she gave me a note that said, this is what has happened since you've been here last. And this was the date it occurred.
Most likely is not going to qualify under child victim hearsay.
No.
I'm not sure you need to spend time on the top,
Agreed.
the bottom.
Mr. Kowalski, don't worry about the time on that one.
Okay.
On the one on Friday, January 6, 2017, where were you when did Maya tell you anything about abuse in that visit?
And Jack, don't read it. Just refresh your recollection and then speak from memory.
First question is, did she?
She did report it to me.
And so let me ask you then, were her statements voluntary?
It was voluntary on her side, yes.
How soon after did you transcribe these into 2380-008?
I usually did it right away.
Within 24 hours? Or
yes.
And what did Maya tell you on that day regarding any abuse towards her?
I'm trying to find out how this might have been, I could be wrong, but maybe my brother is the one that transported her. He reported it. I could be wrong, but I forgot how this
and it's out.
Information.
Did Maya tell you this directly?
Not on that day. I was unable to talk to her.
Withdraw.
Okay.
Yeah.
All right.
That was the day of the court, correct?
May I approach as to exhibit the last one, 2380-013? That's it. 2380-013. Actually, you can see it there.
Yes.
This is when Catherine informed Maya that her mother was getting mental treatment. This is the last part. This has to come in. They have to get this part in.
What
this
I
is
was
crucial
talking about
for them.
earlier.
When, to the best of your knowledge, did Maya tell you about this? And if it's multiple dates, fine.
What's the base number on this?
2380-013. Bates number is plaintiff's.
Mr. Anderson, I don't know the date, but it is. I know it is in this booklet. The dates.
Go ahead. If you can find the date, we need the date.
I don't care if you take 3 hours to do it, but Jack,
from
you need
what's being
that
said.
date. Happy birthday, Jessica. I saw somebody wishing Jessica a happy birthday, but I can't see the original message. I hope it's your birthday. Here it is. It's not Jessica's birthday. She's telling me on the phone right now.
As you're checking there, Mr. Kowalski.
Yes.
I noticed there are some repeats here. What, if any, of these were, again, told you on the Friday 2nd, 2016 date?
The Friday what? I'm sorry.
The Friday the 2nd, 2016 date that you just testified to as to many of these.
Asking Jack another question while he's looking for this is not the right way to help him find this.
(2016) you stated?
What's on the screen
I'm not seeing the date on there.
I understand.
Okay.
We're trying to establish it.
Yeah.
So, were any of these, because you've already testified to many of them on Friday the 2nd, 2016, did Maya tell you one or more of these? What did Maya tell you?
A lot of these were earlier than that.
Okay.
Do you have the scared to talk with the judge?
Okay. What else?
I believe the computer incident was earlier than that. And
It's not so much when they occurred, it's when Maya told you about them. Did she relate these?
Oh, it was before that.
Okay.
Before that Friday.
Can you find us the date before the
Yes.
Friday, December 2nd?
She made little handwritten notes, and that's what I'm looking for. I'm sorry. There's a lot of pages.
Okay, so since they can use things to show him to refresh his recollection, Mr. Anderson's legal team should be going through this. They should have already had this whole thing documented, cross-referenced,
when
and
the
tabulated.
visit before this occurred?
Before, I'm sorry.
Before when?
Before you took down
Hold on a second,
this,
Mr.
well, before this one.
Mr. Anderson, hold on a second.
I understand the importance of this issue, but respectfully, it appears we're at the point where he's trying to refresh where the statements came from that appear to be coming from Maya's notes, that he then took from Maya's notes and then recorded in a summary later undated. I don't know how this lengthy exercise.
That seems to be an argument.
Okay, I apologize.
Circumstances and trustworthiness and all that good stuff.
Yes, Your Honor.
Mr. Kowalski,
Yes,
let's
sir.
just stick with Friday, December 2nd, 2016. If you look at trial exhibit 2380-013, what, if anything, did Maya tell you that was transcribed? Or what did she tell you?
Just stop your question. What did she tell you? Stop.
That was transcribed into a document. This one.
Maya stated that Catherine had brought her to the chapel, placed Maya on her lap, and I said, I know I'm not
Just
your
reading it.
mom,
Here comes
but I will.
objection.
Your Honor, I object.
I mentioned this earlier.
He's reading the note.
I mentioned this earlier without reading it.
Just tell us what you remember she said.
Oh, I remember Maya very upset that Kathy Beatty put her on her lap. I remember her saying that her mom's in a mental home getting treatment, or in a hospital getting mental treatment. Kathy Beatty placed her on her lap, kissed her, stroking her hair, and said that she could be her mom, and then that she wanted to adopt her.
And did Maya state these directly to you, or did you just simply take a note?
No, she told me about it. And the problem with that is if I lose my temper in there, I'm going to lose my privileges. So I had to keep my cool, and it was very difficult to do so.
And again, would Maya repeat to you incidents that had happened earlier in this Friday, December 2nd, 2016 date visit?
Yes.
Anything else you can remember her stating that might fall within 2380-013?
So they have one date he's found in his journal.
And then just tell us what she said.
And they need to fit all this in on that one date. And I don't think it'll stand up under
about
cross.
the computer.
All right, just take it in. All right.
Yeah, right on the top of my head,
All right.
I'm sorry.
Substantially the same as what you've already told the judge she told you.
Yes.
Your witness. And again, Was this voluntary?
Yes, it was.
And was it your routine
That's
to
not the issue.
transcribe these at or near the time?
Yes.
I'm worried Mr. Anderson has fumbled this.
I don't have any further questions. Thank you.
No questions because
Can I ask a couple questions first? Just, I want to finish the testimony and then we can talk about it. So, I guess the additional statements that I wrote down in my notes that you contend Maya told you, was that Maya told you that, was it Catherine Beatty told her that her mom was getting mental treatment?
That is correct, Your Honor.
And it was Catherine Beatty, Maya said it was Catherine Beatty that told Maya that she, being Kathy Beatty, wanted to adopt her, meaning Maya?
That is correct.
And Maya told you that?
Yes, sir.
the judge is doing the questions for Mr. Anderson. He's
And
throwing a lifeline.
Did Maya also tell you that it was Catherine Beatty that questioned her and made the statement about this using the computer and are you on like a sex website or something?
Yes,
like that?
Your Honor. Yes, that's true.
It has to be on December 2nd because that's the only day he was able to pinpoint
And you
in his
also
journal
said that
that's when it happened.
Maya said, and I just want to make sure that
No.
Maya told this to you as
I don't think
opposed
that's the
to
right way to do
someone
it.
else. Did Maya tell you that Maya was scared of challenging Kathy Beatty?
Yes,
When did she tell you that?
I don't know the date, sir, but she was very scared of her. She did not like her.
And how about the statements about not being able to come to court if she didn't comply with Miss Beatty's statements? Was that to you?
She did say that to me in time. I don't know
When
when.
you say in time, was that?
These events
Well,
and
it
dates
wasn't
were
on that
dramatic.
date.
Our
It
brains
doesn't matter if it
erase
was on that
traumatic
date, but
events.
tell me,
This is King Lee.
to the best of your memory, sitting here right now, when she told you that, and tell me the circumstances of those discussions.
I honestly could not tell you the date or approximate date.
Try a
but,
month, Jack.
Sorry.
She did. She brought that up many times.
And has Maya told you about the photographing issues?
She did.
Tell me the first time, if there were more than one, tell me the first time Maya told you.
I know it was when she was still in the hospital. That would have been after that date. I don't know the exact date, but we were informed of it.
Don't say we were informed. Tell me what Maya told you.
Maya told me that she was held down by an individual, and Kathy Beatty said we have to take these pictures before you go with your Uncle Scotty. That's the brother that transported her from Johns Hopkins Children's Hospital to the courthouse in Sarasota. Maya stated that she did not want her to do it, and she basically said, if you want to go to court, you have to let us do this. Maya said it was very disturbing.
And the first time that Maya told you this, who else was present?
I honestly don't know. Usually it was myself visiting or with Kyle, but I don't believe Kyle heard that.
And was this before or after your wife died?
That would have been before.
So we have a time frame. I'm wondering if the judge is going to allow this. The fact the judge is asking these questions.
I'm sorry. It might not have been before. If this was on the 6th. You know what? It could have been. It could have been.
Jack doesn't understand how his...
Defense, any further questions?
No, I would just point out to the answer is no.
Okay. Any further questions for this witness?
Just one. Jack, that last question from the court was perhaps a bit vague to you. The photographing incident, was that before or after Beata passed away?
Well, that's what I was trying to think. That the court date was on the 6th. I'm trying to think if I visited her on the 7th. That's what I'm trying to figure out. If I visited Maya on the 7th, well, I could look real quick if you don't mind. But it may have been after. I honestly don't know offhand right now.
Was the photo? So you don't know as you sit here whether or not the Maya's direct report to you.
I believe it was after.
After we say after Beata's.
I believe so. Because I would have to look, but that sounds about right.
But I heard you earlier say.
I object to the leading, Your Honor.
Just go ahead and answer.
Ask the question. But it was reported to you while Maya was still in the hospital.
Oh, yes, so, it was.
Is it your testimony then that would have been reported to you sometime between January 7th
and the 13th? Yes.
Thank you.
Thank you. That was important.
Anything further?
No, Your Honor. Thank you.
Okay, Mr. Kowalski, you can go ahead and have a seat.
Thank you, Your Honor.
Did you have any other witnesses that you wanted to call with respect to the child victim hearsay aspect?
Mr. Anderson needs to sit down. Maya's coming up. Maya's taking the stand.
Yeah, and you can have a seat. Now, to be clear, what we're talking about right now is child victim hearsay. It's not, I mean, Maya's most likely going to be able to testify to all of this before the jury. It's just whether we get the testimony of someone else as to what Maya told that person.
No, Your Honor, the only person would be Kyle, and he was very young at the time.
So are you going to want to call Maya Kowalski now, or are you?
I think we're okay based on what her knowledge would be at that time outside of what she would testify to.
Okay. Arguments now. And so, I don't know, do you want to plan
Defense
to
wants
go
to
first?
go first.
Sure.
Since you're the proponent here?
Defense has a lot to say.
We have numerous indicia of trustworthiness. Go ahead.
Your Honor, with respect to Jack Kowalski's testimony and credibility, he has provided several affidavits, declarations in this case, deposition testimony. Never has his credibility been questioned. Under questioning here on these particular documents, he was able to refresh his recollection based on his contemporaneous notes. I want to point out that with respect to 2380008, which related specifically to the incident of the photography, he was honest and credible in that testimony because he testified that on the first instance, this was told first to his brother, and he was honest about that. Then, when asked a few questions by the court, he testified specifically that he was told in the hospital within a week time span. If you look at 2380008, there are details that he provided in his testimony that are not within the paragraph Friday, January 6, 2017. Specifically, Mr. Kowalski testified that Mike Kowalski was held down by an individual while Kathy Beatty photographed her. That detail of a nurse holding her down, separate and apart from Catherine Beatty's efforts to photograph her, is not included in what was used to refresh his recollection. So that's an additional indicia that he was remembering details when prodded that were relayed to him directly by Maya Kowalski. So we would ask that the documents be admitted or used to refresh recollection under the child abuse hearsay exception.
Let's have it admitted first.
Your Honor, for clarity, we're only discussing whether or not it's going to be used to refresh recollection. Is that where we are at this point?
No, we're talking about the statements that Maya Kowalski told to Jack Kowalski.
Right.
This is like Inception.
Under the child
What
victim
level are we on?
hearsay statute. That's generally what we're talking about at this moment.
For their introduction or for their use to refresh his recollection? That's what I'm trying to figure out.
For substantive
For
evidence.
substantive evidence, okay. And so, first of all, you need to understand that this is a two-step analysis you're in right now, because this is not a case where there is a cause of action or a claim for child abuse. And so you have to find that a statement was a statement describing an act of child abuse, and that statement is then relevant to an issue in either the battery or maybe the false imprisonment, possibly the medical malpractice, or intentional infliction of emotional distress. And while using the photographs is probably their easiest example, is that does relate to one of their alleged counts of intentional restraint and battery, and so those at least cover part of that issue. But many of these things that they're talking about, that Kathy Beattie told her that, first of all, that she was afraid of Kathy Beattie and didn't like her. That's just not a statement of child abuse. That she wanted to take her computer away, apparently because she was worried about use on improper websites. Again, I don't believe that's an act of child abuse.
Thanks, Thomas. Have fun with the family.
There are several other statements that they've gone through here that if you look at them and say, is this an act of child abuse? It may be something the child doesn't like. It may be something that's discourteous, but it rising to the level of something that's admissible because it is a statement of child abuse. Many of the things that you've just heard there did not fit into that category. So if you're going to enter an order, in addition to going through the requirements of the statute under subsection 23 to make it admissible, you have to find that it is an act of child abuse and that it would be relevant to an issue in this case. And I believe that there's a very limited scope of these that might possibly be used in that fashion.
Okay. Well, I think I understand where you're going, Mr. Altenburn. Did this side want to say something else?
Very briefly, Your Honor, just to add on to my colleague's argument on the law, in terms of the factual declaration given by Mr. Kowalski, he was quite honest with this court that he does not know when these notes were prepared. He was asked that multiple times. He does not know when many of the statements were made to him in terms of dates, in terms of where he was. He is not able to identify in some of the statements what nurse made a statement or what doctor made a statement. So it goes to, the reliableness and the veracity in order to be able to analyze whether the statement could come in as a hearsay exception as well. Thank you, Your Honor.
I think Mr. Kowalski testified credibly that the statements, with the exception of the photography, were given to him, made to him by Maya Kowalski on December 2nd, or perhaps within the 12 hours, 24 hours preceding that, because he had a process and routine of taking her statements and recording them contemporaneously. The fact that Maya related several incidents to Jack Kowalski that may have occurred on various dates on a singular date does not make them fall outside the statute. With respect to the legal argument about findings of child abuse or neglect, I would point out that 803.23 not only includes child abuse, but also includes child neglect or sexual abuse or an unlawful sex offense on or in the presence of the child. Child neglect under the statute is a caregiver's failure.
Are you talking about 827.03?
I am, Your Honor.
That was going to be my next question to both is, since these terms were not defined in 90.803 paren 23 paren 8, do we look to, in this case, 827.03 for the definition, or is the definition in 90.803 paren 23 paren A something else?
From the defense side.
Well, that was just I'm going to want to hear, but Mr. Whitney is...
As an undefined in the statute, when I say the statute, 803.23, we would look to 827.03. There's both a definition of child abuse. I'm going to focus for a moment on neglect of a child, which is a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, which the defense is focused on, nutrition, clothing, shelter, supervision, medicine. There was a specific statement that Mr. Kowalski was told by Maya regarding the provision of medicine, and it goes on. It's also a caregiver's failure to make a reasonable effort to protect the child from abuse, neglect, or exploitation by another person. And so in this instance, she was sheltered at Johns Hopkins Hospital, and Catherine Beatty was the perpetrator. But as we heard this morning, there was a disciplinary record. She had anger management issues. She was not removed. She was not taken off of Maya's case, and so this was allowed by the hospital. So the statements that may fall outside of abuse certainly fall within the neglect in the statute 827.03, and for that reason fall underneath 803.23.
Anything further?
The legislative intent could not possibly have envisioned the statute be construed so broadly that it's going to encompass a caregiver providing care to any medical malpractice action. Should it be construed this way, any medical malpractice action involving a minor, it's merely because the plaintiff alleges a failure to provide medical care, that would not, the legislature could not possibly have envisioned this child neglect and abuse hearsay exception to encompass any time there's medical care or an alleged failure to give medical care in a hospital. I don't believe the legislator intended this.
You said that 4 times. 4 times. Legislature didn't intend this.
That is exactly a basis for it.
Now they're waiting for a ruling. I think some's coming in and some is not.
The court, in medical court report, you might want to mark this as the beginning of a ruling. I don't know if anyone's going to want it transcribed, but let's just mark it here. Before the court is the child victim hearsay motion filed by the plaintiff at DIN 2433. And in this particular motion, we are talking about various statements that Maya Kowalski made to Jack Kowalski in particular. The child victim hearsay statute obviously is 90.803 paren 23. And that statute in A1 and A2 established specific requirements to permit hearsay statements of a declarant child victim who is 16 years or younger to be admitted into evidence in a civil proceeding. The requirements of both of these subsections must be present because they are connected by the term "and."
Now we need to see if they met these requirements according to the judge's ruling.
Even if the both requirements are met, the child victim hearsay is not admissible unless the source of information or the method of circumstances by which the statement is reported indicates a lack of trustworthiness. I'll go ahead and go through this together. And I'm going to assume for the sake of argument that Maya Kowalski will be testifying at trial, that's been told to me that that is going to happen. So under 23 paren A 2A, the child has to testify. And so I'm going to do my analysis, assuming that Maya will be testifying at trial. Section 90.803 23A1 provides in relevant part that the court may consider the mental and physical age and maturity of the child, the nature and duration of the abuse or offense, the relationship of the child to the offender, the reliability of the assertion and the reliability of the child victim, and any other factor deemed appropriate. And the seminal case, and that's not Seminole, it's the other spelling of Seminole, is State versus Townsend, 635 Southern 2nd, 942, pinpoint site 957 to 58. It's a 1994 case from the Florida Supreme Court, and it is widely viewed as kind of setting the procedure, the multiple step procedure that we have to follow. Here, the court conducted a hearing outside the presence of the jury and heard the testimony of Mr. Jack Kowalski. Now, I will pause and say, certainly we've already been through, I'm going to say half the trial at this point, approximately half of the trial. So generally these hearings happen prior to the start of trial, but we are at where we're at. I tend to agree that the statute 23 paren A, I've got to find some sort of qualifying, and I'm going to just use as a shorthand, child abuse or neglect, but the statute is much lengthier than that. Now, I don't think it necessarily is as narrowly tailored that it must be a criminal action, but I do think it has to be tied most likely to Section 827.03 and otherwise referenced in the pleadings. When I say referenced, I mean falls to a count that is in our operative pleading. Here there are a number of statements that were made. Some of them were made on Friday, December 2nd by Maya to Jack Kowalski. Others are made at other times during Maya Kowalski's time at the Johns Hopkins. Let's deal with the easy one first, which are the statements that Maya made to Jack Kowalski. And even though Jack Kowalski did not have the precise date, whether it was January 7th, 2017, or
this one's coming in
sometime between January 7th and January 13th. These were made while Maya was still at Johns Hopkins All Children's Hospital, but at a time after her mom had died. So that leaves us with a 5 or 6 day window. These statements about that Maya relayed to Jack Kowalski about being photographed and that Maya did not want to be photographed, that if Maya didn't go along, she would not be able to go to court or go with Uncle, I think it was Scotty I wrote down, to go to court, and that Maya was scared if she challenged Miss Beatty, and if I didn't say it, that Maya told Miss Beatty not to photograph her. All of those statements clearly are within the pleadings. They certainly can be seen as an act of child abuse, And the circumstances behind those conversations between Jack Kowalski and Maya Kowalski are sufficiently trustworthy for the admission. The time, the content, the circumstances of those statements certainly are sufficient safeguards of the reliability.
I believe that's the battery.
The actual photographs of Johns Hopkins
this one's
taken
coming in.
of Maya Kowalski, so we know
The other ones
as a
are gonna
matter
be
of
harder.
fact that Johns Hopkins All Children's Hospital did in fact photograph Maya Kowalski, and although not discussed during today's discussion on this, we had earlier in the trial in front of the jury, Miss Kathy Beatty tell us that risk management at Johns Hopkins All Children's Hospital directed these photographs to be taken. So
the judge just said what happened
finds those
does
statements
count as abuse.
Have sufficient indicia of
And it is coming
reliability and will permit Jack Kowalski to testify as to Maya Kowalski's hearsay statements. I probably need to say that at the time Maya Kowalski made those statements, Maya had just turned 11 years old. The court will also note, although this is from the totality of the circumstances of the trial to date, and I don't think anyone has contradicted this or is going to attempt to contradict this, but Maya Kowalski, given her long-term medical involvement, is more mature than a girl of her normal biological age. So her level of maturity is higher. The next
But
set
that doesn't mean that
of
she gets treated like an adult.
statements
She still has all the
are
protections as a child.
attributed to a Friday, December 2nd, 2016 conversation between Maya and her dad when dad was visiting with Maya at the hospital, and dad testified that these statements were made outside the presence of anyone else, which is consistent with the content of the types of concerns that Maya were relating. Those included Jack Kowalski testifying that Maya Kowalski said that the social worker, i.e. Kathy Beatty, was hugging and kissing her, being Maya, and making faces when Maya's mom was on the phone. The next one is that the social worker, Miss Beatty, told Maya that the mom is in a hospital getting medical treatment. The next statement is Dr. Elliott told Maya that her mom was putting Maya in a coma each week. The next statement is, and this was less clear from Mr. Kowalski, but his best recollection is that Maya said that Dr. Elliott said something about all of this was in Maya's head. There was also a statement about the use of the computer and Maya possibly using it without any sort of evidence to search on some sort of sex website. Now,
I don't think all these
the
are coming in.
statements about
At least this way.
using the computer to find a sex website or anything like that, even if it's true, is not a statement of abuse or neglect. So that statement is not going to qualify for something that Jack Kowalski can testify to. The statement attributed to Dr. Elliott about all this in Maya's head, because Jack Kowalski was not clear on his recollection of that comment, I do not find that there's enough reliability with that statement. So that statement cannot be testified to. The statement that Dr. Elliott told Maya that her mom was putting Maya in a coma each week. I am on the fence on that one. I'm in my mind, I can see that might be a child neglect issue, maybe. But I'm going to think about that one a little bit more. But Mr. Anderson, right now, my leaning is not to admit that statement, but I'm going to think about that one more. The other statements, the statements that the social worker was hugging and kissing Maya, with the face, making the faces when Maya's mom was on the phone, and that Maya's mom is in the hospital getting medical treatment. Those statements that Maya Kowalski made to Jack Kowalski do qualify as either, or could qualify as abuse or neglect. The court would find that there are sufficient indications of reliability as to those statements to qualify for the child victim hearsay. So I will allow those statements that I specifically advised. Now, to be clear, that does not mean that those documents from which Mr. Kowalski used to refresh his recollection, that those documents are admissible. But Mr. Kowalski's testimony as to what Maya Kowalski told him as to those statements that I specifically said can be used under, or in your case in chief, under 90.803 paren 23. Any questions or clarifications as to my ruling, Mr. Altenberg?
A specific finding then that the testimony is that Ms. Beatty was making faces about things when Beata was talking on, I guess, an iPad to her mother. And your finding is that Ms. Beatty's action of smirking or making some faces while listening to her mother in the room is an act of child abuse.
Or neglect. And because of the outrage count in this case, I mean, that's to an 11-year-old girl when the mom is having very limited contact, and it's supervised, that the supervisor is either making fun or making faces. That when we go back to 827.03, talking about mental injury and talking about the mental health of a person and providing supervision under neglect of child, I think it is sufficient to fall under it. I mean, obviously it's not a battery. I mean, clearly I'm not saying it's a battery, but I do think that the language in 823, that the language in 823 as well as 90.803 paren 23 paren A is broad enough to include that conduct. Any other clarifications that the court needs to make?
The only thing the plaintiff would ask, Your Honor, is that, and we understand as to the Dr. Elliott said everything was in Maya's head. As to the computer, the sex website, introduction of the idea, the concept of porn sites to a 10-year-old, we only ask this, that the court, in light of his rulings on the other matters, at least while you're considering the Dr. Elliott said putting Maya in a coma, that you at least consider reconsidering on the porn site introduction, because in our view that is certainly not towards the mental health of a 10-year-old who has not reached puberty and has no idea really about such things. And there's no indications here that although Maya is very smart and mature, that in any way, shape, or form, first she's reached puberty or approaching puberty at that point, nor is there any indication that she was sexually aware. So putting those things together, we ask the court to consider to reconsider the computer website?
I'm not. And, as I said, Maya has a much greater maturity than at the time on Friday, December 2nd. Technically, she was 10 because her birthday was like a week later.
Yeah.
She's talking to her dad about sex websites. Maya knew what the concept was. And so I'm not going to reconsider it. My notes, I missed one in my notes, and I apologize. The statement made to Jack Kowalski by Maya Kowalski that Kathy Beatty wanted to adopt Maya, I do find is a statement that would qualify under the statute, that there's sufficient indication of reliability and will be allowed for Jack Kowalski to testify to. I forgot, and I apologize for not saying that one, so I will say it. But I'm unsure on the Dr. Elliott. I'm going to spend more time, but I don't think it's going to come in. But
so did
I'm going to reserve on that one.
In the hair and holding it on her lap.
Anything else before we move on to our next issue?
One question, clarification. The "I'll adopt you" statement was made in the context of
which statement?
Kathy Beatty's statement that I will adopt you or something to that effect.
Right, which I just said is coming in.
I understand.
So you want to keep talking about it?
Well, I only want to talk about it in the context of the visit to the chapel, because I didn't hear a finding specifically as to whether, I know hugging and kissing was said.
Her dad didn't say anything about a chapel.
I understood. All right. Understood.
Okay. I know there was discussion about a chapel this morning in Kathy Beatty's testimony, but Jack Kowalski didn't say anything about chapel. Okay. Anything else on this issue? If not, why don't we take a 5-minute break? We're going to end my ruling on that, and we'll move on to exhibits when we come back in. 5 minutes.
Okay. Oh, wow. 5-minute break. Let me jump back here. The judge has gone. The judge has exited the building. That was that was a huge win for the plaintiff. Now realize this is not ruling on whether or not the evidence can come in at all. All of this stuff, every piece of it, even the stuff he said is not coming in, it's allowed to come in with Maya, or probably will be allowed to come in with Maya. That's her testifying directly what she experienced. It's not a hearsay. This is all the child hearsay exception is why they would allow Jack to testify to this, because he heard it from his daughter. So all this ruling that we've just went on is just to address whether or not the plaintiff can have Jack testify in front of the jury about these events, and not get exception, not get ruled that this is hearsay. So we bypassed a lot of the hearsay objections. Now, still, Mr. Anderson, in doing this, presenting to this jury, is still going to have to be able to ask the questions of Jack in a way that allows him, that encourages him, or leads him to the answer where he brings this information out, where he says this, where he testifies this. He can't read it off a document. That will still be objected to, so he can't just pull up the notes and read them. He'll be able to refresh his memory from them if it does, which will be allowed. The documents themselves, his notebook is not going to be admitted into evidence. That has not been determined to be the case, and he won't be able to ask any leading questions. So it still is a big hurdle for Mr. Anderson to overcome, and I don't know, Goodman Law Firm, Nicole, I'm not sure if Nick can take over, because Mr. Anderson has started the direct questioning with Jack, and once that's begun, I don't think they can switch lawyers midstream. So I think Mr. Anderson is going to have to carry on through this one. That's just my gut feel. I was impressed that during this hearing, obviously this is outside the presence of the jury, the judge did allow multiple lawyers to argue the same point. And so when Nick stood up and took over a little bit, that was a good sign. And he was very helpful in doing that. I think Nick does a much better job at some of these direct questioning, especially with Jack, where Jack lived all this, but in his head it's all jumbled together. He just and him saying, "Oh, it's in there somewhere. I don't know when." It's the wrong answer. So many times he gave the wrong answer came out of his mouth as to whether or not this would be allowed. The only reason all this is coming in is because of the judge. because the judge threw a lifeline in clarifying and asking questions of the witness. He asked the questions in such a way, and it was plain, it was clear, they were direct, they weren't lengthy, they didn't lead, and that's how we got to this point. Hopefully, Jack took some notes from the judge today and then answers similarly when allowed next time he's on the stand. Do you think Jack is smart enough to go over his journal? Well, Catherine, we saw him there in court after he sat back down next to his attorneys, and he had what appeared to still be his journal in front of him and a highlighter. So he's flipping through and highlighting things. It would be great. It would be really, really good if when Jack does testify to these in front of the jury, if they use his journal to refresh his memory, and then at that point, he's able to say, yes, that occurred on this date. Yes, that occurred on this date. Yes, that occurred on this date. And here it is. Still, without reading out of his journal, it has just refreshed his recollection. And that's something that really needs to be drilled into his head, that he can look at something, read it, get his recollection refreshed, and then answer a question without reading. Memorize it, says Holly Mack. The judge was definitely swayed in his judgment after Betty's depo. I believe so. I believe that was impactful. Okay. Sherry, sorry, I've got the hiccups. Hold on. Usually just mention it makes them go away. Witness prep is key. And I don't know who's in charge of witness prep. Is it Mr. Anderson? Peter Steele, can the defense still argue the last motion before exhibits? Peter Steele, say that again. Defense, can they argue the last motion? The judge has made a ruling on that motion. He's done. So I doubt he's going to revisit it. Oh, you're talking. Oh, so just clicked in my head. Exhibits are what comes right after this break. Okay, we're gonna, as soon as the door opens back up and the judge comes back in, we're gonna start talking about exhibits that will be coming up most likely during Maya's testimony next week. I don't think they might make a record. They might make another objection for the record or something. But I think the judge is happy with his ruling and won't move from there. Did they even expect Jack to testify to this today? Debbie, no. And so much of this just strikes me as unprepared and just decisions made off the cuff, where Mr. Anderson is like, okay, next we're going to call Maya. And the judge is like, you're going to call Maya to testify in a hearing about hearsay from Maya? He's like, can you just say, think that one through really quickly? How would this help? And they're like, oh, wait, never mind, we won't. And who else do we have? Oh, we could call Jack, but he was too little to know. Why would he even, or sorry, we could call Kyle, but he was too little to even remember. It seems like they're just not prepared a little bit. Look at this. Holly Mack just gifted 5 memberships. Listen to Learn, Minnesota Nice, Todd, Hoodat, Clement, Tasha Turtle, and someone else. Donna, all gifted memberships. Thank you, Holly Mack, for your generosity. It's good to have some more people in green here. They didn't have that in the plan. What they got in was most of it. I would say what they got in was all the key bits. The little tiny bit. I mean, let's see, which was one. What was it Dr. Elliott had said? That your mom's getting treatment in a mental hospital? Is that the one that he's not sure about? We'll see. That's going to be addressed later. I'm also addicted here. I'm here every single day. Thank you. Appreciate the kind words. Let's see. Usually the paralegals are responsible for witness preparation. Nana, maybe this is something we need from Kelly. Hopefully she's healthy soon and back, because Kelly did seem to be on top of it. Anytime there was a question about any evidence, she knew where to find it, what page it was on, how to get there. We need somebody who knows Jack's journal inside and out to be able to go through with, they need to go through and make it a glossary. They need to make an index. They need to have every single date and then a summary of everything that was brought up on those dates. and just be able to flip to it. And then hit every single point, even hit every single time she brought it up, as many times as possible, and just pound that in. I say we need as if I'm on that side. I feel for the family right now. I feel for Jack. I feel for Maya and Kyle, because it seems that Mr. Anderson is losing battles that he didn't need to lose. It looks like the judge is back in here. It looks like he's losing battles that he could have won had he been more prepared.
So we're now to exhibits, is that correct?
Yes, sir.
Okay. Well, let's start.
At the top, the first exhibit is 2123-610.
He did have something happen on a personal level, but this has been happening since before then.
Let's get it up.
Looks like it's from the hospital. Final report. Material has been privileged and confidential. Oh, wait. It's very disheartening to hear all this. This is Lindsay. Lindsay Masika?
So what am I looking at?
You're looking at below is what we're interested in, Your Honor.
Okay, so you're looking at the Kathy Beatty email and not the Lindsay Masika?
I expect there's a hearsay objection on that portion, but with Kathy Beatty, this is a party admission. This is a statement of Ms. Beatty and relevant to the lawsuit here.
This is Kathy asking that phone calls with the mom be suspended until the court gives more instructions. And she gives the list. Mother noted in her phone conversation today she had tried to have a phone visit with the patient on Thanksgiving. All children was just too busy with their own families and didn't care if we could visit. Mother also asked the patient if she got a letter that mother sent to Kathy Beatty at Johns Hopkins Children's Hospital. No letter was received from the mother to Johns Hopkins. Mother covered up the following topic. Oh, there it goes. Hope you got your screenshots.
So, what are the issues?
The simple issue to discuss is Ms. Beatty has been dropped, so she's no longer a party, where this would be admissible as a party opponent. The broader issue, again, I know we're sounding a little bit like a broken record, but this is starting to relitigate what happened at the dependency court. And the problem with admitting this email is the only way to start refuting the hearsay in this is to talk about, well, what happened next? Well, after November 29th, this information went to different lawyers, and then they went to a dependency court, and then four lawyers for the Kowalskis made their point about what visitation should be. Lawyers for DCF, including Mr. Silverstein, made recommendations about what visitation should be, and all of that culminated in people other than Johns Hopkins All Children's Hospital, who was not a party to the dependency, with the court crafting orders. And, you know, our general fear about getting into this testimony, which is probably somewhat out of the barn, unfortunately, but this is going to crack the barn wide open, is it's out of context. And the only way to talk about these is to talk about the next 100 actions that resulted after this email, all the arguments that were made to the dependency court, who made those arguments, what orders resulted. I'm sure we're going to have a discussion about what can the jury see in terms of some parts of the redacted
There's the whole
orders,
document if you need the screenshot.
This is getting really deep into how the sausage is made and is going to create issues for this court that I believe, you know, could result in a mistrial if we're starting to talk about what happened with dependency. That is our objection.
Ooh, threatens the mistrial.
Do you need a response, Your Honor?
Yes. Yes, please.
Yes, Your Honor. With respect to party admission, was made at the time by the party.
Well, it's clearly a party admission. I'm not. It's whether the other side of Mr. Shapiro's argument is what I'm focusing on.
Thank you. Well, The defense has requested an instruction, and I think the court's going to give one on the scope of the court orders. And we have been consistent that what was happening here is the hospital was feeding misinformation to DCF in an effort to get court orders to tighten the vice grip on the Kowalskis. And so this is a perfect example. The lead social worker in the case is characterizing the phone conversation that she listens in on without authority and characterizing that phone call as being damaging to the child, and then suggesting to DCF that for the reason of Beata allegedly acting improperly during that phone call, that DCF then should then push for additional restrictions on Beata Kowalski's limited already visitation with her daughter. And that's exactly what happens. So we need to be able to point out, since the court orders are coming in, the jury's been very curious about these court orders, what was the genesis of these court orders? Was it really just the hospital implementing orders and DCF instructions, or as we've pointed out, was it the hospital taking advantage of the situation and leveraging their information from listening in on phone calls to push DCF in that direction?
And it's not addressed to any attorney. This is strictly communication between DCF, and the court has previously ruled that these DCF memos do not have the force of law. So it seems like they want all the good parts about the orders, and they don't want to get involved at all in how they manufacture some of them. And let me say one other thing. If the court hears the actual phone call that this is referencing, which we want to put into evidence,
I think I've actually already listened to that one.
all right, then the court can compare for himself exactly the difference between what was represented and what was on that call.
Ms. Crowell's was standing up earlier.
Yes, I know, but I'm deferring.
Please, the court. I think Mr. Whitney just kind of gave away the game. Game that plaintiffs are playing here is to relitigate in detail the dependency action. Theory that Mr. Whitney just elucidated is that there were statements being made to DCF or the dependency court that were incorrect for whatever reason they believe, and that forms the sole basis for the court's ruling, and that if those things weren't done, then there would not have been this ruling. They are relitigating exactly what the theory is in the DCF and the dependency action. We've taken the position from day one in this case that there is an immunity that derives from any act or omission that is permitted or required by Chapter 39, and there is an immunity for any act or omission that is connected with the judicial proceeding that was the dependency action. If there was a problem in the dependency action, the remedy was for one of the 4 lawyers, arguably 5, counting the gal lawyer, one of the 5 lawyers representing this family, to take it up with Judge Hayworth at that time and to deal with it at that time. What's going on right now is that we are going into detail on orders, detail on the execution of those orders or the interpretation of those orders, detail on what was being told to DCF, and everything connected with the DCF proceeding as well as the dependency action. This is going to the heart of relitigating that very case that you've been saying that we thought we understood was being avoided, and yet here we are, and it's going. And this will open floodgates that have already been opened by the rulings on what was permitted from Ms. Beatty's deposition. There is more than confusion being created regarding what DCF is responsible for versus what the hospital is responsible for. We can't defend what we did without going deeply into all of the orders and all of the machinations of DCF. The fact of the matter is that the court in the dependency proceeding heard from multiple lawyers and multiple witnesses, not just all children's, and made a decision that in the final analysis was at variance with what was recommended by the hospital. So, Judge, I just want to make clear that in continuing to permit exploration of what was told to DCF, what was told to the dependency court, what was recommended to the dependency court, what the orders consisted of, what happened in the dependency court, and continuing to do that, we are invading an immunity that should be respected and we should never have crossed to begin with.
Let me ask this. As of November 29th, what was the status of the court order with respect to communication and telephone calls? Can someone give me that order?
Scrambling.
As of November 29th,
I'm looking.
farther down.
It's the order, I believe, dated November 10th. I don't think it had been changed
November
since
10th?
then.
Okay.
And it says,
Can someone hand me a copy of it, or
We have an exhibit number if you find it.
give me the dependency case number and give me a DIN number? I can pull it that way as well.
Order on shelter
I'm
review.
not sure I can give you a DIN number. Then I had given you a proposed standard instruction that had the ordered and adjudged part of all of those.
What is the dependency number? Does someone have that case number?
Yes, the dependency number is case number 2016-DP-601-NC.
And you said, Mr. Altenburn, that this was, the most recent was it was November 10th?
10th.
So the order was on November 10th. This letter comes out on November 29th.
The relevant paragraph, Your Honor, I believe is paragraph B at the top of page 3.
Okay, well, that order looks like it was.
There's a note that date. That's.
Yeah, I'm trying to find it.
I have a copy if Your Honor would like to see it in hard copy.
I love the whispering right into the microphone
Or
as
I
if
can
they
put it on
can't
the
hear
other.
us. Yeah, the comment where they said they had 4.
Okay, so the dependency
five
court
lawyers
signed it
to
on the
count the gal
10th, but
lawyer.
it was docketed on the 14th. Okay, let me read it. And you said it's on the
Yes,
third
that's
page?
correct. That's correct, Jeff.
You said it's on the third page?
Page
Yeah.
6th page.
Oh, well, we have a different number of 10th order. Ours says contact between Mrs. Kowalski and Maya on the third page.
Is that in the body
Is that
or
right?
is that in the order? The ordered and adjudged part is what I'm
I
reading.
think Mr. Shapiro agrees with me.
Yeah, I see.
What does it say on page 3? Because I don't have that.
Got really quiet here as everyone's reading. They've got a 6-page order they're all scrolling through. I'll move out of your way. Here, go ahead. Take your screenshot. There you go. There's your screenshot. You got it, Mandy? Give me a thumbs up if you're good. 5, 4, 3, 2, 1, 0. There we go. Now, Mandy, stop pushing me around. So, just kidding. I'm just going to go out on a limb here and say the guy with the headphones by all those cables, I don't think he's a true crime junkie. I think he's only here for the money. I don't think he enjoys his time here.
Let me ask a dumb question.
Oh, goody. This will be good.
When the dependency court said telephone communication between the mother and Maya is authorized, but only when supervised by the guardian ad litem or the case manager at times convenient to them in the facility, why is Kathy Beatty monitoring the call?
That's not a dumb question.
Boom.
From my recollection of the DCF hearing, if we can go back on that, at some point in time, because the guardian ad litem and the case manager couldn't find time to do these, it was okay for her to listen rather than one of the other two, is my recollection.
We have a different recollection.
Okay.
And she testified to it this morning. She decided that the best way to communicate with the mother between Maya and Beata was for Kathy Beatty to use her personal cell phone and walk into Maya Kowalski's room and set the cell phone on speakerphone on the bed or near Maya and remain in the room during those conversations. That was her decision. Yeah. And during those calls, there was the authorized supervisor from, what is it? Does it say in the order DCF or the guardian ad litem?
Judge,
okay, but Ms. Beatty also testified that DCF asked Ms. Beatty to basically perform their function.
Yes, that's correct, Judge, especially, and she would come in on the weekends to do that as well because they were not available and wouldn't get the calls connected.
Show us that particular email or memo.
Respectfully, Judge, in addition to that, if there was a problem with it, the remedy was to go back to the dependency court.
Right.
Just as if there's a problem with something that goes on before Your Honor in this court, our remedy is to come to you in this proceeding, not to file a collateral action seeking damages.
Yeah. Well, explain then how we are supposed to know about this.
Time out. I'm reading this email from Kathy Beatty to all the people that are effectively the DCF folks. And it is a recommendation to DCF as to how the order should be changed. This doesn't, and frankly, that's how it should be done. It's like, if they don't like something, this is, go to the folks who are going to go to the court, and this is what the hospital is going to recommend. I see that this is part of the dependency process. And so, my inclination is this is not something that would be admissible in this proceeding.
The problem is that we in the dependency action, nobody knew about this. This was not copied to anyone. It wasn't copied to the other lawyers. This was not a proceeding where you had the court's approval, sanction, or anything else, because it was unilaterally and not only that, but I think that My Florida Families is a contractor of DCF. Nonetheless, the problem is no one knew anything about this, and this was not submitted to the court. No one knew that Ms. Beatty was the only person at Johns Hopkins who was sending this in. This is from a social worker. This is not from a manager or anyone else at Johns Hopkins. This is from a social worker who purportedly, according to them, has no managerial responsibility or anything close to it. So why are we having a social worker write to a third-party contractor, not copy anyone from the lawyers for the Kowalskis at that time, trying to manipulate it, which then results in the next order, which I think is the 1227, which includes no disparaging comments shall be made by any visitor. The problem here is that this was not part of the regular system. This was not part of what the court envisioned. This was a social worker without authority writing to a third-party contractor, influencing the system. And this is not something that would have ever been shown to the court, and it would not have been shown to in the proceedings. It would only go to this contractor, who presumably would then influence the DCF attorney, Silverstein, who we plan to call. And then from there, Silverstein would decide what to do. So the actual decisions, yes, down the road. But the point and the relevance of it is the hospital is allowing Beatty to influence the court proceedings unbeknownst, and keep one other thing in mind we want to emphasize in this. The hospital was not a party. The hospital was not supposed to be dictating or influencing court action, other than if there was a direct violation of the court order or a specific rule that the hospital handed down. And our case is this. The patient's rights set forth the rights that the Kowalskis relied on and had the right to rely on through this. Yet the hospital, and not even the hospital, I think, basically Ms. Beatty was coming up with bizarre rules, strange inferences, and conduct that was totally out of line, and was trying to influence the proceedings as though the hospital was a party. And if you look closely at some of those transcripts, Judge, I think what you're going to find is that the hospital, far from being just a participant, which under Chapter 39, they're not supposed to be influencing the proceedings. They are not supposed to be advocating one way or the other. They're simply supposed to be observers. And yet, there was a lot of advocacy and a lot of trying to get this done. And so our point is, there's got to be a cutoff. At some point, the court will have to rule, but there needs to be a cutoff below that.
Let's talk about cutoffs for a second.
Yes, sir. I've
been given a 7 or 8 page list. We're still on number 1. We're 30 minutes into this. Yeah. I hear what you're saying. Let me tell you my thoughts right this second. This email goes to the question of whether the dependency court should or should not change the contact. That is an issue within the dependency court. I don't see why the request to change the rules is something that we need to address in this case. Now, having said that, in my mind, and Mr. Altenberg, you might want to raise your antennas on this because I think it's going to impact you the most. I can see an instruction by me saying, as of whatever date, November 10th or 14th or whatever date this was, the contact by Mrs. Kowalski was allowed to be supervised by the guardian ad litem or the case manager at a time convenient to them in the facilities. I can then see an interrogatory question that says, did DCF delegate its role under this order to Miss Beatty or the hospital? Yes or no? If the answer is yes, then there would have to be an instruction that, you got to disregard the concerns about the contact starting on November 10th to whenever that court order ended. If the answer of that is no, then the hospital had no authority to monitor that call and then could be part of the...
So we're going to have to put on testimony, put in all the transcripts of these hearings and read the hearings where this is discussed?
The issue, I think the issue is whether DCF authorized Kathy Beatty to operate
They're going to have to
under this court order in DCF's stead.
They gave her permission to listen on the phone call.
And if the jury says yes, then what Miss Beatty was doing was under the authority of the court order. If the jury says no, then I don't see a court order that would have allowed Miss Beatty to listen in on the call.
So I guess I call Mr. Zimmer. the lawyer, Mr. Silverstein, and the people from DCF to explain this whole process to them?
No, just whether, as of this date, that they had authorized, because I can see the court instructing the jury to the extent on as of November 10th. I keep on saying November 14th because that's the day it was docketed.
Right.
And you know what I'm talking about there.
Yes.
But as of that date, the court, the dependency court, stated that the communication between the mother and Maya was to be supervised by the guardian ad litem or the case manager at a time was convenient to them and the facility. There's nothing here that says that the facility can listen in. Now, if Miss Beatty was delegated the authority of DCF, if you will, to operate under DCF's position or the case manager's position under this court order, if that's an issue of fact and the jury says yes, then it would seem to me that all of this discussion about
I disagree.
Listening in on conversations, we have to tell the jury to disregard.
And this is relevant to which they're intentional infliction. I'm not sure what it's relevant to.
I think
to me, that's kind of part of an outrage, listening in on someone's telephone conversations without authority.
Well,
there's outrage that goes to the claim.
First of all,
See, this is why it's relevant.
Mrs. Kowalski knew it was going on because this was the conversation where 3 or 4 times there was an interruption to say, no, you got to redirect, you can't go there. And so she knows that the woman is on the phone with her.
It's not whether she knows, is whether Miss Beatty had any authority to be on that telephone call.
Judge, respectfully, if
the defense
that's the case,
has to prove that she had authority.
Kowalski's aware that someone is monitoring the telephone conversation outside the parameters of the court's visitation order, then the remedy at that time is her lawyer takes the matter back to the court, as indeed they did several days later in a day-long hearing before Judge Hayworth on the terms of the visitation.
Mr. Hunter, on this November 10th or November 14th order, can you show me any paragraph that authorized the hospital to listen in on the telephone call? Can you point to me?
I can't. All I'm saying to you, Judge, is if the complaint is, let's assume for the sake of discussion that Ms. Beatty's testimony is to the effect, as it was this morning, that the Guardian and myflorida.com, that is DCF, by the way.
I know.
That they were unable, unwilling, or not staffed to provide that. And so she did as she said she did and supplied herself to do it. Now, if you assume for the sake of discussion that's correct, and that she stepped outside the parameters of what she was supposed to do, then the remedy for that, her acting outside the court's visitation order, is to go back to the dependency court. And what I'm suggesting to Your Honor is that's exactly what happened. Because
the cops
if you
are all
look at the
busy in my
dependency
neighborhood,
action,
I can't
about
just pull
10
someone
days
over.
later, on about December 5th, 6th, there was a day-long hearing with everybody, with all parties, mom, dad, the child, the gal, everybody represented by counsel, where they went over exactly what the visitation terms are. What I'm suggesting to Your Honor is that you can't get into this, and you're correct to some extent on this, but what I'm suggesting to you is that the entire issue of this is part and parcel of the dependency court's jurisdiction in that proceeding, and if you start going into it, we're relitigating it.
I fundamentally disagree. I see the question differently. As I said, when I look at this email, I see this as a request ultimately to the dependency court to alter the court order on visitation.
And the judge sees that in favor of the defense.
To me, that is an appropriate action within the dependency court proceeding to change the court order. But as of November 10th, the dependency court had issued an order that, in my mind, when I'm looking at it, does not authorize the hospital to listen in on the conversation. Now, I'm either being put in the position where I have to make a factual finding, which I don't think I'm allowed to do since we have a jury here. So to me, it's a question of fact as to whether or not DCF had delegated its authority under the November 10th order to allow Ms. Beatty to supervise those conversations instead of the case manager. If the jury finds the answer to that is yes, then we'll have to have an instruction to the effect of, then members of the jury, you cannot consider anything having to do with the supervising the telephone calls as any type of conduct that would have a finding of outrage or damages. But if the answer to that is no, then I think it's fair game. And so I think the evidence for that is whether or not DCF authorized Ms. Beatty. That sounds like a pretty limited scope of testimony as opposed to what happened later on in front of Judge Harris. That I don't want to get into, and I don't think you need to get into that. I think you just need to get into, as of November 10th, this is what the court order said, and it clearly doesn't give the hospital the right that you think it does, and it's a question of fact as to whether there was a delegation.
Judge, what I'm suggesting to you is that is not the only issue like this that the court's going to be confronted with.
Well, this is issue number 1 on this sheet that we're now 40 minutes into, and I don't think I'm changing my mind on this right this second.
I would urge Your Honor to consider it, that's all.
Judge, can I?
Folks, if we are ever going to get to number 3 on this list, not to mention number 400 on this list, we have got to do this faster.
I understand, Judge. But is the court reserving ruling on this? Because I think the court needs to hear from DCF or somebody on that issue before it allows this in, because if all the testimony is she had the authority, then this email should not come in.
I already said that, to me, this email should not come in.
Okay, sorry.
I said that 20 minutes ago.
Yes, you did, sir. I'm sorry.
Okay.
But I wanted to be clear because I've seen this issue now as to where I thought this whole thing's going to go, and I was alerting Mr. Altenburn to the possible jury instruction that I'm envisioning is going to have to be given.
Okay.
I understood, Your Honor. I'm trying to alert you to where I think it's going to go, and this is the first step in a long path.
Well, maybe we can agree to disagree at this point.
Currently, the email is not coming into evidence.
We're the ones that have...
Time out. Only one at a time. It's Mr. Altenburn's turn.
It's not. The email currently is not coming into evidence. Is that right?
Correct.
Okay.
Currently, it's not coming in. That was their concern.
I'm telling you that the issue of authority, because I know I've already talked to you about wanting to do an instruction that talks about the visitation and the dates and the times, and I can see that being a specific issue that the jury is going to have to make a factual finding on. What's next?
2270, Your Honor.
Okay, Mr. Altenberg,
there was
back. He's
3 or 4 others.
He's the attorney over jury instructions.
Okay, so 2270. And this is
Ricky,
from
thank you so much.
to Dr. Amin.
Yes, Your Honor. There's a second page.
Let me see number 2, please.
There's page 2.
Who is this to?
To Dr. Well, it's only addressed to Dipti Amin.
No, but this letter, which is 2270-002.
It doesn't say.
Judge, they know that ultimately this turns into a letter from Dr. Amin in the dependency court action, isn't it?
This is an internal email from Kathy Beatty to Dr. Amin.
He's avoiding the question.
Okay. Can Mr. Reyes, can you make 002 a little bit larger for me, please?
Make it big. Let us be able to see this. Get your screenshots ready. Here we go. Okay. So they're trying to get this in as an internal.
Whitney, this goes to the same issue that we were just talking about, that this letter, because it sounds like this was ultimately delivered to the dependency court to advocate for a change of visitation in the dependency court. To me, that is off limits and not what this trial is about. The fact that someone made a suggestion to make visitation more rigorous or less rigorous is not an issue in this case. It's ultimately when the dependency court ruled what was followed or not followed.
Understood. I think there's a way to deal with this letter through specific redactions, taking out mention of recommendations to DCF
Judge
and then
doesn't want to
ultimately
do
the
that.
court. For example, what you see here, don't stay there. The top paragraph that's displayed right now, for example. This has to do with Catherine Beatty's statements about how Maya's doing in the hospital, which is absolutely relevant to the case. And goes to her credibility, Maya's credibility, and what was going on.
I will tell you, yes, if everything about recommendations to the dependency court, recommendations to DCF and supervision and all of that is excised, and all you have is the observation and statements about Maya, I would consider that.
All right. We will put those redactions to them.
Yeah, we'll have to see the redaction, Judge, and then we'll have argument.
Yeah, I mean, but if it's an agent of Johns Hopkins Hospital making an observation about how Maya Kowalski was physically doing an observation, that's probably going to be relevant and admissible. But nothing about making a recommendation to the dependency court for changing a visitation. That's not coming in any exhibit that you got.
In the interest of time, we'd like to advance a couple of pages. I think it's the third page, although my page is not numbered. And get to the audio clips, which begin at 2608A, 2608 Alpha.
And before we start playing these audio clips, are all of these clips, have we cleared any sort of potential criminal problems with these clips?
These are calls between Maya Kowalski and Beata Kowalski, the first.
So in this case, Jack Kowalski as Maya's guardian could consent, and on the other side, Beata, who hit record, is obviously consenting. So
I'm just clarifying, there's no one else on the call?
No. Catherine Beatty, at times, will, in supervising the calls, interject herself into these calls.
It was Miss Beatty, was she aware?
She was. It's announced at the beginning of the call that by Beata Kowalski, I'm recording this call. And secondly, there has to be a reasonable expectation of privacy. And I know we just went over these letters, but she characterized the contents of these calls and reported the contents of these calls that she was on, so she has no reasonable expectation of privacy in these calls.
Not only that, but they're on a speakerphone in a hospital with people walking by. There's case law that says that in exact that circumstance where they're in a hospital in a place where it's a speakerphone and anyone can listen in.
Well, before we get really down this path, I've heard conflicting things as to whether Miss Beatty was going to waive or not waive.
Not waiving.
Not waiving. Okay. So if Miss Beatty was on the call and it was announced that the call is being recorded and Miss Beatty did not object, then it would seem, without even having to hear it, that she's waived, she being Miss Beatty has waived any expectation of privacy, assuming there is any. But is that actually the case?
We'd have to listen to the beginning. I think the first clip includes that announcement, if not right before it. Do we know?
What's the date of the call, please?
This phone call is November 15th, 2016. And the first clip that we would like to play for the court is 1 minute and 13 seconds.
I'm just going to put this out here.
Do you have the consent at the start of the call that we could hear before we?
This court,
as I stand here, I don't know if it's within this clip or just before it.
They're not ready for trial. Neither
I
side.
just don't know, Judge. Sorry, there's too many clips. I don't recollect off the top of my head.
I would feel more comfortable if you could assure us that no one's going to jail by playing this clip.
So we'll play it to ourselves.
Play it privately.
Yes, please.
Go ahead and listen to it.
Grab the audio guy's headphones. Okay, he's putting his headphones on. He's got his little earbuds. I'm surprised he doesn't have a pair of like Beats Pro headphones. Are they going to share earbuds and do like one left and one right? Okay, here we go. Attorney's going to listen. Go ahead and hit play. All he's listening for is the very beginning where Beata says, "I'm recording this call." And Beatty, boom, that's all he needed. That's it. What is it? Come on. Oh, come on.
You said this is 2605?
2608.
2608. A is an alpha.
Yes, Your Honor.
Here we go.
Flipping back to courtroom audio.
I've got it to his.
Perfect. I was just letting you know that was the delay. I had to switch it back.
Oh, okay.
I was doing it privately. May I publish?
Yes.
Okay. I'm recording this phone call so everybody knows. Okay. Hi, Mommy. Hi, honey. How are you, sweetie pie? I'm hurting. I miss you. I miss you so much, too. I miss you so much every day. Every single day. You don't know how happy it makes me feel to hear your voice. Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice, too. Yeah. I hope you. What did you say, sweetie? I hope I can see you soon. I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay?
Maya never
as soon
saw
as
her
he
again.
makes the decision, then I'll be able to see you. Okay?
Beata?
Yeah.
Beata, we're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Is that the conclusion of the clip?
Yes, Your Honor.
Yes.
Okay. Are B and C the same call?
Yes, they are, Your Honor.
Why don't we just, and
Roll-
I'm assuming
roll tape, roll
that
tape.
at no point in the interim anyone has removed consent. Is that correct?
I've listened to it. No one removed consent on this call.
Thank you.
Thank you, Mr. Alton.
That was a stipulation. So
Then you can play B as in Bravo.
How you doing? How is PT and OT going for you?
Not good.
Why is it?
Okay, Beata, we can't discuss any of those type of matters, okay?
Okay.
Is that the conclusion of Bravo?
Yes, Your Honor.
Let's listen to Charlie.
Charlie is 55 seconds.
And what do you usually need help with?
My pants.
What happens with the pants?
I just can't lift them up.
You can't pull up the pants anymore?
No.
When did that start, Maya?
Oh, I don't know. Maybe a while ago. I don't know. Yeah. I don't remember when it started. Okay. PBH.
What's PBH?
Yeah, I'm going to redirect that line of conversation now, thank you.
Okay.
Does that finish it?
The end of that one.
Yes, Your Honor.
Okay, so that concludes that telephone call that you wanted to publish.
Yes, Your Honor.
Okay, go ahead and what is the argument, or let me hear the objection, I guess, is where we need to start.
Well, Your Honor,
I move to admit.
object hearsay, certainly as to all of Beata's comments. I don't know what the relevance is to what issue, and 9403. I mean, it's clearly just to appeal to the emotions of the jury. Those are the arguments. I mean, it's hearsay, it's 9403, and it's not relevant to the issues.
And Mr. Altenberg, going back to that last discussion we were having for 40 minutes
Yes.
On the factual findings, there probably also needs to be a factual finding as to if the jury were to find that there was a delegation, we need a date of the delegation, because
What is the date on that phone call?
this one's 11/15, which would have been the day after the order was docketed, which is why I just am in my mind thinking we probably need to find a date of if the jury were to find that there had been a delegation.
And thank you, Judge. That brings up another issue. If there's an issue with the manner in which Mrs. Beatty was handling this call, that's an issue for the dependency court. And they want to use this to try to say that Mrs. Beatty wasn't appropriately monitoring the calls as directed by the dependency court.
But again, if Miss Beatty had not been authorized by DCF, and clearly the dependency court did not authorize the hospital to monitor the call, then under what authority was she acting on November 15th?
The call
Well,
would not-
that's, go ahead.
The call would not have taken place at all because there wasn't somebody from DCF or a guardian on that phone calls, is my knowledge.
Clearly she's assisting in placing the call, Judge, but I heard Your Honor. So I would suggest that there needs to defer on the admission of this until that testimony is heard, because you can't put that cat back in the barn.
But here's the conundrum I'm in. At some point, someone has to make the factual determination on the delegation and when.
But if
there's no summary judgment that was addressed to this issue. And so how am I supposed to take an issue from the jury?
If there's no dispute as to the fact, if there's nobody that's going to testify otherwise, if DCF comes in and says, yes, we asked her to do it, if the attorney for DCF comes in and says, yes, we asked her to do it, and there's no factual dispute, then absolutely the court can make that determination.
Can the jury disregard the testimony of Ms. Beatty and potentially of DCF?
If there's nobody that testifies in contradiction, how could they ignore that, Judge? There's not going to be, if there's no contrary testimony. If DCF says we gave her the authority, we asked her to do it, if the attorney says we asked her to do it, and there's no contrary evidence, there's no factual determination for the jury to define. That's all the facts. That's all there is. That's a directed verdict.
No, not at all. This is a summary judgment standard. You're arguing summary judgment standard in open court.
Well, summary judgment is now married to directed verdict.
Right.
Yeah.
I understand, Judge.
They got married?
However, the jury does
Congratulations.
have the right to reject that testimony. if
What's
they
their
so
kid's
deem.
name?
And if they find that Mr. Silverstein at that point either did not have enough information or that he did not have the authority, if the court finds he did not have the authority. And so there are a number of hoops to jump through here.
So now they're going to argue, Judge, and try to prove it to this court and this jury that the DCF didn't have authority. That's a DCF hearing.
No.
I go back to the dependency court order. It says telephone communication between the mother and Maya is authorized, but only when supervised by the guardian ad litem. And obviously, it doesn't seem like that's an issue here. or the case manager at times convenient to them in the facility. So
There's nothing in the complaint.
Is it a common law marriage?
It's 105 pages saying that she was listening in on conversations in violation of the court order. This is all quite a surprise to me, frankly.
Well, the argument just came up by the defense on this. We were arguing outrageous conduct and limiting access to Maya.
Yeah, I am comfortable that this issue is contained within the pleadings. It's what I'm hearing Ms. Crowell say is if the defense only presents evidence of DCF authorized or the case manager authorized Kathy Beatty and there is no contrary evidence, then why put this information in?
Yes, Judge, because then you're putting something in that needs a limiting instruction, as opposed to they have to first, I would think, establish the basis that allows it in. So I would think before this comes in, they would have to establish that she. Anyway, that's my argument. That you would allow them to put in evidence that then has the fifth limiting instruction for this jury, as opposed to waiting.
Anything else, Mr. Anderson?
Yes, I had a brilliant point, and now it just escaped me. However,
they call that a senior moment.
It strikes me that the issue is not going to be presented in the plaintiff's case. So it would have to be at the conclusion of the defense's case. And at that point, if the court decided that it was a DV, then the court would have to, in the instruction, say, as to evidence regarding this, this, and this, the court instructs you to disregard that, which happens in almost every trial. Not every trial, it's not like a slip and fall, but in every big complex trial, there are instructions about what evidence you can consider and what evidence you can't. So it can be corrected at the end.
I tend to agree with Mr. Anderson on this. I hear what the defense is saying, and ultimately you might get a DV on this, but maybe not, I don't know. But I think the question that the jury has to answer is whether or not they were authorized, that the hospital through Miss Beatty was authorized.
If the court is
the court order doesn't say anything about the hospital.
If the court is inclined to let it in, then why is all the preamble coming in up to the point where Miss Beatty interrupts the call?
Because there's other exceptions for those statements.
If the point of this is to show Miss Beatty interrupting the call, then it should just be the parts of Miss Beatty's interrupting as opposed to the rest of the call.
Well, when Maya's talking to mom about not being able to pull up the pants, that seems to be something that really the hospital should have been told about for medical purposes.
Well, what about the mom's response, Judge? That's hearsay. The conversation between the mom and the daughter, maybe Maya's comment can come in as I can't pull my pants up, but then you have Beata's comments back. Let's see if here's an exception for that. It's a conversation.
What is mom's comments being used for the truth of the matter asserted?
Exactly.
The judge used that one.
I'm pretty comfortable with 2608
Not for the truth of the
A,
matter
B, and
asserted.
C coming in. Now, Mr. Anderson, at the end of this trial, if there's a DV and I grant the DV,
There'll be a mean instruction.
there's going to be a very strong instruction about what they're going to have to ignore.
I understand.
Okay?
Your Honor, just so it's clear in the record to you that while the part about the phone calls with Mrs. Kowalski being supervised, and the previous one that says that the communications with Maya, Mr. Kowalski, and Kyle, which were more open, are not to discuss her pain or its causes and shall be positive as to her rehabilitation efforts and progress, and will also follow the recommendations of faculty staff as to how to interact with her. So what's going on in this phone call was what was ordered for everybody else in the family. And that's discussed with some length in the DCF hearings. So the one that's coming in with her interrupting things that none of the other family can do with her, I don't understand why that's coming in.
I'm going with what the dependency court order says, not what was talked about in the dependency hearing, unless that is the actual court order that we've got to address.
This is a paragraph in that same order. So unless she's exempt because she can have the supervised calls, Mr. Kowalski was actually promising he could work with her to get her to obey this stuff at some point.
I guess I'm not following, because paragraph A says contact between Maya, Mr. Kowalski, and Kyle Kowalski.
That's correct.
And it doesn't say anything about Beata Kowalski there.
You're right. It does. The other one doesn't say I incorporate this by reference. So she could just talk about any old thing she wanted to.
Purple.
Is your position?
If you've got social media, go ahead and do that.
Perhaps when you
awesome. Just tag me
and
in
Mr.
share it on
Allegate
yours.
present to be the jury instruction about the dependency court orders, we can have that discussion.
As
But
Mr. Zimmerman explained yesterday, these things were complicated, and she had to interpret these things as just read them, because these are not plain and unambiguous orders. So,
I hear what you're saying.
okay.
And I'm trying to make it all make sense for everybody. So 2608 Alpha Bravo and Charlie can come in.
The phone calls are coming in.
What's next?
The recorded phone calls.
2627A. This is a audio recording made at the time of ketamine infusions at Dr. Kirkpatrick's office.
And did everyone give consent?
Dr. Kirkpatrick has consented.
Is there anyone else besides Maya, Mom, and Dr. Kirkpatrick?
I need to listen to the 15. I don't believe so, but let me just verify one more time.
What's the date?
October 8th, 2015. No, it does not.
Defense is in a tight spot because the judge is putting them on their heels. And Nicole Goodman, you made a comment earlier saying that the plaintiff has to find somebody at DCFS saying that she did not have authority. The judge is putting that on the defense, not the plaintiff. They're saying we have a court order that says these two parties can participate in the monitoring of the phone call, and Beatty is not one of them. Oh, they're playing it for everybody? Are we all getting to hear this? No, we're not. Okay. Anyway.
Just Ms. Kowalski and Maya.
They're putting that back on the
Then
defense.
let's play
And I don't think there's any documents to prove that.
2627 A as an alpha.
Kiss, 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 kiss. I love you. I love you to the moon and back. Love you. I love you to the moon and back.
I'm not sure if this is coming in.
What is this one for?
What's the purpose?
Moaning in the
relevance?
background, you can hear the child in pain.
I don't think so.
Yeah.
And
No.
it was going to be used with Dr. Kirkpatrick as well to explain a few things about the testing at that point and the pain Maya was in. Excuse me, the discomfort she was in at the time.
I don't think this clip
Okay,
is,
put it on
is
the next one then.
good for that issue at all. So I'm going to deny.
What was the number of that again, please?
2627 A as an alpha. So what's the next clip, Mr. Whitney?
2631 Alpha. And
This is a different date.
this is now October 12th, 2015. We have it's like 6 clips chosen from this
Hey, Nicole.
recording.
And again, do we have a consent issue, or is all consent issues
The only
resolved?
participants in this would be Dr. Kirkpatrick, Maya, Beata, and Jack may make an appearance in 1 or 2 of them.
This is from Kirkpatrick.
Didn't Beatty counteract that? Isn't
Let's
she
play
the opposing
2631
testimony?
A as an alpha.
Saying that she just did it herself without authority? They were
Here we
just
go.
busy, so she took over.
Okay, so anyway, so you can see that her short-term memory is pretty botched, and that's good. That's a good thing. We want that. That's what we want to do. So we can say she got an adequate dose. So the max we could ever do on her is probably 135. I mean, that's for her size and everything. That's pretty good, type thing. So, but we wanted to have that as a record. So we're going to put down here. No. This is just moving around because she's in this weird thing. She's probably in God knows where you're at. I mean, you could be on planet. Well, I can't say planet Pluto anymore because it's not a planet anymore. They call it it's a satellite
Pluto.
out there. But anyway, you're far out. Yeah. So he's thrashing around and all that kind of stuff. And the thing is, you probably don't remember much of that at all, right? Okay. And that's normal. That's perfectly normal. But the thing about it is, it's one of these things where you're just trying to balance things out, not giving enough, but not going crazy and going overboard. Okay. Because we were concerned she got a hyperactive airway. If she gets stressed too much, we could activate that end of things, which we don't want to do. So I think we managed to balance this thing out in a fairly good manner. We didn't have to give her, and there were times when I didn't even give her any Versed. Okay, remember?
Yes, on the third day, she didn't get any Versed till the very end.
Yeah, right. And she seemed to handle that pretty good.
Yeah, the last day. I'm sorry, not the third day. The last day.
Right.
The first 2 days were hell.
Right.
But the third day was better. The fourth
and sometimes
day,
what you do, you just try something like that and just see how she does. If she does fine, then the less Versed we give it, the more ketamine can do its job. Okay. All right. So I'm going to put down, but I want you to understand why I'm putting no adverse hallucinations where she's yelling and screaming, trying to run out the door. Right.
Yeah. The first 2 days she wanted to get out of there.
Yeah, right.
She was seeing monsters. Yes, she saw monsters the first 2 days. Those 2 days were really hard. Trying to calm. Okay, Maya, I'm talking. So it was hard to keep her calm. But then on the third day, it got a little bit better. She had pleasant hallucinations,
Mm-hmm.
She was
dreaming. Yeah, she was dreaming, talking to God. It was pleasant. And then on the last day, she was laughing. Yeah. She was high. Floating high.
She was having a party.
Yes.
So Creed on this.
She didn't have no nausea, vomiting.
No, she had one after the first treatment.
So that's the end. Beatty was monitoring in addition.
What are we using this for, Plan?
The other supervised call.
Statements for medical purpose. Then
She wasn't allowed
existing mental, emotional, physical condition.
Did I understand that right?
Of the doctor?
Plaintiffs laugh. They know it's a bit of a stretch.
Well, clearly it's not being used to prove whether Pluto is a planet or not.
Judge, it's clearly a hearsay. I mean, it's the doctor going on and on and on and on and on. It's no exception applies to that.
I'm going to give you another opportunity, plaintiffs, if you could, because I'm about ready to to agree with the defense.
We're not going to argue strongly on that one.
Okay. Well, I'm going to deny the admission of A as an alpha. Now, is Bravo, Charlie, Delta, Echo, and Foxtrot all kind of the same?
There are there's less verbiage by Dr. Kirkpatrick than the others. However, again, we're approaching the end of the day, so we'd like to advance again on the list to the videos that we have listed here towards the end of the list. And the first one is 2686. It's only 3 seconds.
What day is this from?
January 8th, 2016.
Isn't this about the same time as her and her brother in the pool?
That's a little later. That was in August of 2016, Your Honor. This is shortly after she returned from Mexico.
Don't blink or you'll miss it.
Just a moment.
Sure.
Thank you.
Cute girls. Really cute. Got it.
Judges.
See it again, please.
Judge
Cute
blinked.
girls. Really cute. Got it.
Cumulative, Judge. I think there's several photographs similar.
It shows her using her feet differently.
We don't have a video or a clip from this time frame, which is clearly relevant because they want to attack the treatments in Mexico and argue that they had detrimental effect to Maya Kowalski. So the other video, as I just mentioned, was from August, and this is shortly after she returned.
The important thing is the legs, Judge.
I saw it and show some dystonia too.
It's cumulative.
Might come in.
I'm going to deny the cumulative. I will
coming in.
allow 2648, A as an alpha.
They're going to have to pause it
next?
during the middle of that to get the effect.
What was the number on that chart?
2648, A as an alpha.
I thought it was 2686.
Yeah.
I apologize, Madam Clerk, I was wrong. It's 2686. Thank you all for keeping me straight. Apologize about that. What's
next?
next?
One is 26900.
And this is April 24th, 2016, and it's approximately.
I don't know how many
just under a
objections
minute
I've
long.
missed here, but they've
Depicts
objected to
Maya
several of these
secretly
things. So we're going to
recording
put a few more.
Beata swimming, and the only thing she says is "I love you." And it's
Looks like a wicker chair.
Gunfire? That was a loud one.
Uh-huh. If you're watching this, Mommy, I want you to know that I love you. Send you kisses. You'll know it's from me.
I'm sorry, Judge, that was who in the pool?
That was Beata Kowalski swimming and Maya Kowalski videotaping and then narrating and making the statements.
Objection.
What's the objection?
803.1, spontaneous statement describing or explaining an event or condition made while perceiving it or immediately thereafter, or excited utterance, or then existing mental, emotional, or physical condition.
Doesn't meet any of those.
Business record? No.
Business record? Who says that?
That would almost be funny if it was 1 o'clock.
It'd be hilarious at 11:15.
Judge, it does, I would think it does fit then, the then existing mental, emotional, physical condition, because it definitely shows what her state of mind was as to her mother. The reason we want this in is that you've got Dr. Lewis's report in which he's saying that through this period of time that there was an antagonistic relationship between Beata and Maya. This video, as short as it is, demonstrates Maya's state of mind as to her mother during the period that Lewis says it's supposed to be a antagonistic one.
Good try, but no.
One more try. 801.2 says a statement is not hearsay if declarant testifies at trial. Why is that declarant? And the testimony, and then the statement is consistent with declarant's testimony and offered to rebut charge of improper influence, motive, or recent fabrication. The entire allegation of Munchausen by proxy is that Beata had an improper influence on Maya Kowalski.
So the relationship between the two should be admissible.
Judge is saying no.
Good try, no.
I thought the last one was the best bet. They should have started with that.
What's next?
Then this will be 26901. This is a short video, only 46 seconds of Maya in scuba practice in the pool, April 30th, 2016, being led around by her father.
They're going to fight this one.
Your Honor. Cumulative.
What is the objection?
I'm going to overrule that. This shows Maya's abilities in April. There was the video we just let in January. There's the videos in August, and there's been testimony about the progression of her improvement in that time. So I'm going to allow 2691 into evidence. Next one.
We'd like to show then skip to, in the interest of time, 2695. It's a video of Maya with her walker at home on the ground and then her upper body strength. It's July 28th.
Well, before we play this one, what did I do with the one where she's dancing in the bed? Didn't I let that in?
They withdrew that.
Oh, they withdrew it. Okay.
Yeah, and I got a copyright strike.
We have another one, but
or a copyright claim on that one from
They
Megan
withdrew it
Trainor.
at that time. I'm not saying they withdrew
video
it.
of Maya playing on walker at home, July 28th, 2016. It's 2695.
2695. Let's play
28 seconds.
Better not be music on this one.
That's better. I love you. Now go down slowly. Go down slowly. Good job. Good job. Very good. Excellent.
She claimed it. It wasn't a strike. It was just a claim. And I fought it and won.
Overruled on cumulative, I will admit. That was 2695?
Yes, Your Honor.
What's next?
It's not that
I'm
Megan
we'll
Trainor
play it,
personally
but
did
I'd like
it.
to have it available anyway. 26903. Video of Maya, again, same date essentially. 7/28/16. It's her dancing in a wheelchair to a Megan Trainor song.
Oh, no.
And that ties in to some
Okay,
other
guys, I have to mute
testimony
this.
about what happened to
As
her
cute
with
as it is,
nurses and Megan Trainor.
we have to mute it. 3. Oh, see? Boom. Cannot. Just move your body. Oh, hey, oh. Everyone sing along. You know the song. Yeah. Megan is at home, Mom. I got a copyright claim if I don't mute this. I'm not allowed to play this. You can sing the Oh Way Oh song. Little dystonia still there, but some leg motion for sure. So everybody else just got struck.
Than they did when I was that age. Like I said, I'm not sure. We're kind of moved to admit.
Cumulative.
I'll allow that one. I will tell you, Mr. Anderson, that we're getting pretty close to my limit on the number of these videos.
I think that's about it on that.
And this is under the, I did not admit in the other dancing video.
Yes.
Because you withdrew it, right?
Fair use is very hard with
dancing
music.
video.
Very, very hard with music.
Okay.
I think it was the same song, though.
You just take them.
Well, that's her favorite song. So she plays it up.
Chases tomorrow, Bug Dugger. I have to edit it tonight.
Considering we're 7 minutes away from 5 o'clock.
Well, let's get a couple of audios in and then we'll be.
Do I ever get to do my motions?
See, Mr. Altenberg, you need to like.
It's a potted plant. I'm sorry.
Come sit up front or something.
Yeah, they do need a few more lawyers over there. I've noticed that. They're running short of them.
Oh, you should talk.
2580, Your Honor.
Folks, let's try to keep it.
I'm sorry, the number?
I'm sorry. I appreciate the number. 2580.
The date? Is it a video?
It's a photograph of Maya in 2020.
20.
2580.
Oh, and then we have a number of photographs we'd like to move in.
How many are in this series?
Well, this is a singular photograph, 2580. And Your Honor, this depicts her at the time of her relapse in 2020 and hospitalization.
Cumulative.
I'm not sure what this one shows.
Are you going to have other photos of relapse, or is this the only one?
This is the only one I'm aware of at the moment.
So it's coming in.
I think we have very limited evidence of photographic evidence of that. So.
What does this photo tell us?
Other
than she's sitting in a hospital bed.
If you notice her hand and her arm, it shows the weight loss. I think
also the hand is starting to. We need. Actually, Maya's testimony will be instructive on this because she's going to talk a little bit about how, when the CRPS came back, the symptoms that she was having. So,
and I'm also didn't realize this. There's 4 photographs in here. If we could scroll through them quickly and show the court.
Oh, there are 3 more apparently.
This shows the feeding tube that she was, and again her collarbone. You can see how much weight she lost. Can you go to 3? Another one with the feeding tube, and there you go.
So he'll allow one of those, I think.
To be very briefly heard on this, Your Honor, the only concern we have, again, the affidavit written by Ms. Kowalski regarding this was that the stress of litigation and specifically depositions was what caused this, the need for the feeding tube, etc. So we're concerned about the prejudice of them making arguments that this was all caused by counsel.
Well, I don't think it's correct that the only stress she had was the litigation. I recall there being issues with school and think there was something else. So, I think we're going to eventually, as soon as Mr. Altenberg can come to the front of the room, we're going to get an instruction about the litigation stress.
Yes, Your Honor. Thank you.
But I think with respect to this one, can I see the series of 4 photos again?
I would suggest one of them, Judge.
I see one.
I think they're going to go
We'd
one.
like to have the first
I think
two.
they're going to go
We
those
show
2.
The collarbone, and it would be good to show her in the wheelchair or bed. Sorry.
So what's number 3?
Looks like
3 and 4 are identical. She's just smiling.
Okay. I see 1, 2, and then either 3 or 4 as showing different things. So I'll give you 1 and 2, and then I don't care between 3 and 4, but 3 and 4 seem to be the same thing.
We just need those 2.
All right, we'll take.
Well, okay, we'll take one more.
We'll take 3.
Okay, so 1, 2, and 3 can come in, but 4, no. Just to make the clerk's job harder.
All right, Your Honor. The last exhibit number, I believe, that we want to discuss is 2571, and it's a series of photographs taken by Jack Kowalski during Maya's admission in the hospital.
When you say a series, I see at least 51.
Yeah, and we're not trying to move 51 and...
So you're only moving or seeking to move in 4, 12, 13, 14, 17, 18, 24, 28, 42, 45, and 51?
Yes, Your
Judge,
Honor.
I would point out that I think 2571001 is already in.
Yes,
that one looks familiar.
When I get to my cumulative argument, I would point that out.
Okay. The purpose of these photographs, well, the selection of these photographs is based on that they're taken on different dates during her hospitalization, and they show the presence of either dystonia or lesions over the course of her hospitalization at Johns Hopkins Hospital.
Okay, what's the next one?
So that's 4. 12 is the next.
And what's the next?
And then 13. 14.
Wait a second. Go back to 12, please. Okay. 13. So go to 14, please.
It's the hand curling.
17.
That one.
Isn't that already? I've seen this one before. Is this one already in?
I don't know, a similar one was.
Don't we have something like this already?
Whose job was it to count objections?
The date's important, Your Honor.
Where are we at right now?
To juxtapose against the medical record. So that's why we've chosen these dates.
18, please.
As far as focuses, like that.
24. $28. Haven't I seen? Don't we have photos of like in the Christmas dress and the head? I think we've already seen several of those.
I think you might be right as far as December Christmas Eve 2016 is concerned. So we can withdraw on 28. What is that? 28.
Let's go to 42, please.
Now we're on New Year's Eve, or close to.
Shows the progression of the lesions.
45. So essentially, 42 and 45 are the same day and showing the same thing?
1 day apart, Your Honor.
Can you go back to the 42?
Your Honor, this date range here is particularly important to us because this is right around the time when the hospital began taking the position that Maya was self-inflicting these wounds. So to show their presence over a period of time and their progression is important.
And 51.
January 5th.
I see that. Defense position.
Cumulative.
Okay, the court is going to find that each of the photos that I'm going to admit show a different, unique condition at a different time. So I'm going to admit in. Wait a second. Did 2571 4 12 13 14 17 18 24 28 was withdrawn, so that is not being admitted. 42 45 and 51.
Can I read those back to you, Judge?
Yeah, do you want me to just read them again?
Please.
All in the series of 2571 4 12 13 14 17 18 24 42 45 51.
That's a lot of pictures coming in.
Is that all the exhibits that you're going to deal with today?
This gives us an idea of what's coming up with Maya's testimony.
Some limited time on Monday morning to discuss any additional exhibits in this list that we can narrow down further and maybe come back with 5 or 6.
Yeah, we'll try to do it as we'll tighten it up, Judge.
We
know what you're.
You need to really tighten it up.
Yes, sir.
Let me just tell you.
We needed a little bit of guidance on what the court wanted, but now we know what to do.
What are you doing as far as witnesses on Monday?
I'm going to call Jack back, and then I'm just asking him the questions from the rebuttal of Beatty. So he should take, I hope they're not going to cost long because there's only a few questions. He should take 45 minutes. Then Maya, will be on. And Maya, I think, will take the entire day with cross. I mean, maybe not, but I expect to have an hour and a half, maybe 2 on direct.
Are you going to do the child victim hearsay statements with Jack Kowalski on Monday?
Yes.
I'd like to, as a predicate to Maya's testimony.
So Monday is Jack Kowalski followed by Maya Kowalski?
Correct, Your Honor.
Now, Mr. Whitney was talking about timing.
I think you went under, so there's up for an hour and a half to 2 hours.
You think I need more?
I really
need more than 2. Mr. Whitney's telling me I might need 3.
Jack took all day.
Yeah.
Judge, here's our issue.
We're doing the best we can to get them on and off. We're cognizant of our time, but I think we need to call Jack. The jury wants to hear from him. And then as to Maya, there's a lot of evidence that goes in through her.
Judge, here's our issue. They've already called Mr. Kowalski once. This will be the second time, and then they're going to put him on a third time for another issue, and maybe a fourth time for another issue. We believe that they should be calling him just one more time and finish his testimony as opposed to continually putting him in front of the jury.
It's their shot clock, and if they want to keep calling somebody back multiple times, so long as it's not like a doctor that is being inconvenienced or a nurse that's being inconvenienced. If it's a party, it's fine, but the shot clock's going to keep running.
And very briefly, my understanding is you, just for notice to the other side, you plan on calling him for the purposes of talking about the issues that you wanted to and potentially child victim hearsay? You're not getting into damages. I'm just trying to prepare for the
No. I hadn't planned to do that. I had planned to call 3 of them back for a short session on damages right before we put on Bifolco or like that.
Okay.
But after Brewer.
Thank you, Mr. Anderson.
Mr. Holmberg.
I was hoping maybe Monday morning I could get hearings on those 2 jury instructions.
How much time do you?
I think I can do both of those depending on how they respond in 15 minutes or less. So.
If we start at 8:15, and we're going to start with Mr. Altenburn issues.
Mr. Altenburn gets to go first.
And I need you all to remind me to do that.
Jury instructions first.
So I don't just
first thing in the morning.
go to exhibits.
Which 2 instructions are we discussing? So I can relay to Mr. Elliott.
The limiting instruction and then the one that I sent in this morning.
Okay. Wasn't aware of it.
One's the Facebook limiting instruction, and then the one on litigation stress. Is that?
Yes, it's a litigation stress.
I didn't pay attention.
Thank you.
And perhaps
I did not file that. I sent a copy to everyone, but I can file a file.
And did Mr. Elliott, did he oppose, or have you all worked on it?
Frankly, I've had very limited contact with him on this week. So.
Is it like Wreck-It Ralph or something?
Perhaps
I have no
maybe
idea.
tomorrow, you and Mr. Elliott could spend
I'll see
a
whether
moment
I can send these to
visiting.
him and see if I can coordinate.
Yes.
And Judge, if we could have the tightened up exhibit list so we're not spending time looking at things that they're not going to try to put in.
Can you get them the tightened by, let's see, today's Thursday afternoon, right? So by lunchtime on Saturday? Does that?
That'd be fine, Judge.
We can do that.
So noon Eastern Daylight Time on Saturday, the exhibit list is
$5
tightened.
says it's late.
I hate to ask anything else because I really think we need to call it.
Yes.
So I'll see everybody on Monday at 8:15. 8:15.
Thank you.
Thank you, Judge.
Thank you.
And we are out. All righty. This is exciting. Okay, so here's where we are. I'm not sure. Amber, are you here? Clipson's Vixen? I'm not sure if we even have you here today. She says, I text her, she says, sorry. Birthing puppies, she says. I'm not sure. I don't think that's personally, well, observing or assisting with, but the way the text came across, I think she's busy. Purple Pros, in answer to your question, first of all, I can't say that word. Apparently, I said it wrong. I thought it was consortium, but it's consortium. Consortium. I don't know. Consortium. I don't think they're going into that. Crystal says, I'm definitely going to court Monday. Awesome. I'm not sure what the rules are on what to wear, but Hey, look who joined. Brandy, the 13th jurors just popped in. I think we just got rated. Awesome. One thing I'm super excited about. I'm not sure. Brandy, is Brandy here? Let's see. Let's see if Brandy has made the jump yet. The portal, it might just be opening right now. If Brandy's here, I just want to make sure this is public knowledge before I announce it. Hello, 13th jurors. Let's see. Watching to see. There she is. Okay, Panda Express. There we go. Brandy, you've updated your name. I like it. It stands out. Is the upcoming event, is that public knowledge? I mean, I've been missing. I've been very busy with this, so I don't know. Can I announce that? I think I'm hoping yes. Yes, okay. So Brandy's doing her celebration for her 10,000 subscribers on Sunday evening, and there is going to be all sorts of prizes, hilarity, fun will ensue. You'll want to be there for that. It's going to be awesome. I know that there's a lot of different things to be sent out and given out and awarded, and reminiscences and fun questions, and it's just going to be a fun time. So Brandy, first of all, congratulations on 10,000 subscribers. That is amazing. That's amazing. Great job. So excited for you. That is on Sunday at 7 p.m. if I remember correctly. Then tomorrow there's no court here in this trial. Because of that, we have some other stuff going on. We have a police chase where we have 3 different videos on that I need to edit really, really badly. Brandy, you're amazing. Thank you so much. We love what you do. I have to edit a video tonight for the police chase so we can show you tomorrow because it is so good. Oh, it's so good. So we're going to edit that together, get everything lined up and played. And we have that. We don't have court. I don't know if we can pull off this medical panel or not. I need to talk to Amber to see what's up, and she's birthing puppies right now. On Friday, Dr. G is celebrating, and he also has hit a milestone. He's hit a huge milestone there with 100,000 subscribers. He hit that this morning at 5:30 in the morning is what he texted to me, which is huge. Just awesome. Great community over there. So he's invited me over there. So I'll be over on that one for Friday evening at, you said 6, right? I think it's 6 p.m. for Friday evening on Dr. G's channel. And then after that, we have, sorry, I'm in the middle of things. Then after that, we have the podcast, which is Mrs. R.A. and I are doing the podcast. So I'll go straight from Dr. G's celebration, have about a half-hour break, and then we're going to do the podcast where Mrs. R.A. will appear on the channel. I've convinced her to appear in person. I don't know where she's going to be, but she'll probably be on an iPad and talking over that. It'll be wonderful there. Police chase. What time are we starting tomorrow? I think because we don't have court, we need to sleep in just a little bit. We need to sleep in just a wee bit. So I'm thinking, is 9 too late? I think we should be able to do that. So Brandy 10K is 8 o'clock Eastern. Okay, 8 o'clock Eastern for tomorrow. I was thinking, so 7 o'clock the other Florida time, right? Because they've got 2 time zones. So 8 o'clock Eastern for Brandy's celebration. And Brandy, if you can send a StreamYard link, that would be awesome. I'd love to pop in if you're willing to accept a raid or something. Let's see, on that it would just be me just crashing the party. Cheryl Baby says Sunday I get to find out the gender of my grandbaby. That's exciting. Okay. Ivan says, well, love is a strong word. Yes, we love the 13th jurors. We really do. So lots of celebrations this weekend. 6 p.m. Friday for Dr. G. That's going to be exciting. Then Sunday, 8 p.m. Eastern for Brandy on Brandy's channel. That's going to be exciting as well. Lots of fun to follow. Tomorrow, we have the police chase in the morning. I don't know. Honestly, this is how bad I am. I have done nothing to line up the medical panel that we have many people who have volunteered, and I know Amber did a ton of work vetting some people, but I don't know where we're at on that. So I need to check with Amber, and she's in the middle of, her dog's having puppies. So I'll talk to her tonight and see where that goes. Either way, we've got the police chase in the morning. We'll have some stuff during the day. Dr. G in the afternoon, the podcast at night. It's going to be just back to back to back fun all day long. And Brandy's actually at 10,800 subs, so she'll probably be by 11,000 by the time of the party. This is what I'm saying. It grows exponentially. She's doing so well. The word gets out and it just explodes. And I remember telling her, one day you'll look at this and look back and say, remember when? Yeah, this is going to be fleeting. It's going to be huge. I'm so excited for her. Let's see. Jennifer says, thank you for joining Dr. G to celebrate. And am I getting some questions together for Mrs. R.A.? Yes, please. This Mrs. R.A. is the chat we're going to have. We have a rough framework, courtesy of guess who? You're right, Weather Watch. Not me, no, but Weather Watch. On his day off, as he's going to be off with family, he has put together the rundown for Mrs. R.A. and I for our podcast. I tell you, this podcast could not happen without Weather Watch. He's amazing. So that's we've got that, but we're definitely open to questions. Brandy Link, yes, exclamation point Brandy, classy girl. If you do exclamation point Brandy in chat, we'll get you the link to her channel, and you're gonna love it. Honestly, right here, that's the code. Anytime we're live, you can type that in, and then if you wait for like a second or two, the bot will reply. Come on, there it is. The bot will reply with the link, and that'll get you over to Brandy's channel. All right, anything else we need to follow? Weather Watch is amazingly amazing. He definitely is. I like the alliteration. Anything else we need to do tonight before we wrap up? Because I have to get some editing done and spend some time with my kids. I'm hearing no objections. Going once, going twice. Boy, what a long trial. It's a long one, but oh my goodness. I was going to say, anybody who is still here listening to this stuff after half a day of lawyers litigating back and forth before the judge, you really ought to consider enrolling in law school.
I object.
I object. Yes. Thank you, Adam, for that great timing. You have to, you really should consider, and I'm doing it. I'm having so much fun doing this. It's like studying for the bar exam has got to be very similar to what we just sat through. Let's see. Hashtag widowed life, says Adrielle Hillis. Started a channel. That is awesome. That is awesome. We'll have to take a peek over there sometime. I'm the guy. Or he's the guy, someone. All right, let's see. I think we're done. Let's go ahead and wrap it up. I've got so much editing to do, and I have to get things done. What's the @ for? It's a indicator of a hashtag or a, what's it called? It's a short name. Oh, guess who chooses now to call? Who chooses right now to call? Hey, Amber, how's it going?
Hey.
How are the puppies?
Is that correct? I have 4 that are hungry at the moment.
Oh, that's cool. What kind of puppies are they?
Between American Staffy and Cane Corso.
Cool. So here's the $1 million question: If we schedule a live tomorrow and I give you a StreamYard link, do you think we can pull off a discussion that people would want to watch and talk about the medical aspects of this case?
It's entirely possible. I just need to know what time so I can get with the people that I've already spoken to.
Okay.
Let's see if they're able to do it at that time.
Let's try for a 10 or 11, and you tell me which one. I'll send you a StreamYard link, and everyone will be able to click on it and just join the link. Does that work?
All right, sounds good.
Okay.
That works.
All right, sounds good. So thank you, Amber. Good luck with the puppies. It sounds wonderful. Congratulations. So, thank you so much. We'll see you.
Not a problem.
All right, bye.
Bye.
All All right, the music's still playing, so we still have time to wrap up. Thank you, everyone, for being here. Thank you to all the mods. Tonight, when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again, which will be tomorrow morning, 9 a.m. with the police chase you will not want to miss. It's going to be fantastic. Thanks, you guys. Have a great night. Be good to each other. We'll see you.